All right. Good morning. This hearing is called to order. I'm Commissioner Tony O'Donnell, the presiding officer for this hearing. With me today is Commissioner Dr. Andy Bukacek. Vice President Fielder and Commissioner Pinocci are attending the hearing remotely. President Brown is excused, but will be reviewing all the transcript of this. Commission Attorney Amanda Webster will be advising the commission. Commission staff are also present. The hearing is being transcribed by a court reporter with Lasofsky Court Reporting. I always think I'm going to stumble over that word over there. So for the record, the time is 9:04. The date is Wednesday, September 25, 2024, even though my script says 23 down here. The commission and its staff are appearing from Helena, Montana, in the Bollinger Room of the Montana Public Service Commission. This is the scheduled public hearing in docket number 2024.07.047 involving the petition of Yellowstone Energy Limited Partnership, or YELP, to set terms and conditions for a qualifying small power production facility pursuant to Montana Code Annotated 69-3-603. I will now take appearances of counsel. Please introduce yourself and who you represent. Petitioner.
Good morning, Mr. President, Commissioners. My name is Thor Nelson of the law firm of Holland and Hart, here on behalf of Yellowstone Energy Limited Partnership. Appearing with me today is Austin Rushoff, also of Holland and Hart.
Very good.
Good morning, Mr. Chairman, Commissioners. Ann Hill on behalf of Northwestern Energy.
Thank you. And we have another intervener, Montana Consumer Council. He is not here. Is he expected to be?
Mr. Chairman, good morning, everyone. Please enter the appearance of Jason Brown for the Montana Consumer Council.
Very good. Thank you. I wasn't aware that you were with us there. So recesses will occur at convenient times during the hearing. I will next ask for public comment. Is there any public comment in the room? Is there any public comment online? None there, all right? So are there any informal questions from the parties before we begin the evidentiary hearing?
No, Mr. Chairman.
Mr. Brown? Mr. Brown?
No questions. Thank you.
Thank you. Very good. So seeing none, we now move to the evidentiary hearing. Based on the parties' pre-hearing memos, there are a few items we should address. Let's first address the admission of data responses. The parties have filed pre-hearing memos identifying responses they propose to admit into evidence. The commission did not receive any objection to those proposals. After reviewing both YELP's and Northwestern's pre-hearing memos. Oh, sir, sorry. Please. Oh. Very good. After reviewing both YELP's and Northwestern's pre-hearing memos, it looks like all data requests are proposed to be admitted into evidence. Is that still correct?
All data requests identified in the motions are admitted into the record. We agree with that.
Very good.
Yes, Mr. Chairman.
Okay, so ordered. Northwestern, it looks like you did not do okay. Okay, good. Northwestern requested the commission judicial notice of two documents. Northwestern's 2023 Integrated Resource Plan, filed in docket 2022.11.102, and the PURPA Title II Compliance Manual 2.0. Ms. Hill, would you like to speak to your request?
Yes, Mr. Chairman, the 2023 Integrated Resource Plan is what is relied on in this case for the avoided cost data. And there is no objection, as I understand, on that for the commission to notice that. And then the Title II Compliance Manual version 2.0 is has NARUC as a participating party that relies on that document, and we thought that would be helpful for the commission to also take notice of. But that one, there is an objection to that one.
Mr. Nelson, you filed an objection?
Yes, Mr. Chairman, Commission, as to the, what is called PURPA 2 Compliance Manual, our objection was specifically related to the way in which Northwestern has proposed that to be admitted into evidence, which is through administrative notice. The PURPA 2 Compliance Manual is not something which is within the Commission's records or files. It is not an official publication of the Commission or of any entity within the state of Montana. It is not a court decision or court precedent of any court within the state of Montana. And as such, we don't think it is appropriate for that document to be admitted as administrative notice. Whether and the extent to which that may be admitted for some other purpose or in some other manner through the course of the proceeding, I think we can.
Says basically, if you don't put bifacial panels in a tilt, which of course costs extra money, then there's no actual beneficial value to them. And I'm creating a list.
Okay, we've,
Okay.
that's done. Okay, proceed. Sorry.
Setting aside that, and so obviously, to the extent it's offered in some other way or for some other purpose, we would reserve. But as to the way it was offered in Northwestern's pre-hearing memo, we would object and think it is improper administrative notice.
Thank you. Ms. Hill, you just stated that you find it would be helpful to the commission. Does that reach the threshold of being admitted or something just to be helpful?
We understand the objection and we will just await your decision on that.
Okay, Ms. Webster?
Ms. Hill, could you clarify if the request for judicial notice is asking for judicial notice of information in the manual or the fact that the manual is found on a certain website?
The fact that the manual is found on a certain website.
Thank you. Mr. Nelson, do you have any response after that clarification?
So I guess I will respond as follows. I don't know what it matters that the information is found on a certain website. So just for the commission's clarification and for the breadth of the record, this document is cited in a footnote in one of Northwestern's witnesses' testimonies. And in that regard, we, YELP, have not objected to the testimony or the footnote reference, which is there. I don't know what else the record needs in terms of the website address of the document. And my understanding is that the request was to take administrative notice of the document itself, which we certainly object to. If I remember correctly, and I could look it up, I actually think the website address is in the footnote. And so from that perspective, if that's the only thing being done, I think that the testimony speaks for itself with the footnote, and I don't know what other additional action would be necessary to complete the record.
Thank you for your response.
Thank you. So if Northwestern is asking for a judicial notice of the fact that the manual is found on a certain website, that also fails to meet the standard of Montana Rule of Evidence 201B. The commission does not generally know the contents of publicpower.org and is not able to readily verify that the website is a reliable source from which to download a PDF of the manual. So the commission declines to take judicial notice of the PURPA Title II Compliance Manual 2.0. So there's again, there's no party objected to the request. The commission takes so therefore the commission takes judicial notice of Northwestern's 2023 Montana IRP filed on April 28, 2023 in Commission Docket 2022.11.102. Are there any other formal pre-hearing matters such as requests for accommodating witnesses, stipulations, or evidentiary motions?
No, Mr. Chairman.
No, Mr. Chairman.
Mr. Brown?
No, Mr. Chairman, thank you.
Thank you. Okay, so let's proceed to opening statements. Would Petitioner YELP like to make an opening statement?
Yes, thank you. Mr. Chairman, Commissioners, good morning. On behalf of Yellowstone Energy Limited Partnership, or YELP, which I think through the course of the hearing will oftentimes pronounce as YELP, we are here today asking the Commission to set reasonable rates, terms, and conditions for a power purchase agreement and associated interconnection agreement between YELP and Northwestern Energy. By setting reasonable terms and conditions for the sale of energy and capacity, the Commission will allow YELP's power plant in Lockwood, Montana, located just outside of Billings, to continue to reliably serve Northwestern's Montana customers for years to come. Just a little background on the facility first. The evidence will show that YELP's power plant has a capacity of 65 megawatts and is fueled with waste petroleum coke. Petroleum coke is a solid fossil fuel that is similar to coal, but instead of being mined, it is produced as a product of petroleum refining. In this instance, the petroleum coke that the plant burns is a waste product produced in the petroleum refining process. Because the fuel is a waste product of refining, the power plant is eligible to be what is called a qualifying facility under the Public Utility Regulatory Policy Act of 1978, sometimes called PURPA. This means that under the federal law, as this commission is empowered to implement, YELP has the right to interconnect with and sell power to Northwestern Energy at what are called avoided cost rates, and under such terms and conditions as may be determined by this commission. YELP has been in commercial operation since September 12th, 1995. While the project's nameplate capacity is 65 megawatts, over the past 30 years or so, YELP has operated with a maximum output of about 62 megawatts, net of the load that the plant uses itself to operate. Year over year, the plant has been able to consistently deliver an average of about 57 megawatts of capacity and energy to first the Montana Power Company and now Northwestern Energy. For decades, YELP has been an established, reliable electric generation resource for Montana. Approximately 52 people are employed to operate and maintain the YELP facility, not including all of the people employed at the refineries throughout the state that supply the fuel for the plant. However, the current power purchase agreement, or PPA, between now YELP and Northwestern is set to expire on December 31st, 2008. Therefore, the YELP is requesting that the commission set specific prices, terms, and conditions. It certainly is. Thank you, Mr. Chairman. 2028. As a result of that, we are requesting the commission set prices, terms, and conditions for a new 20-year PPA that would commence on January 1st, 2029. Following the commission's decision in the recent Colstrip Energy Limited Partnership, or KELP, CELP proceeding, there are many areas that YELP and Northwestern agree on. For example, YELP has accepted Northwestern's preference that the energy price paid to qualifying facilities be set at the applicable market price. And YELP has proposed, and Northwestern has accepted, many of the PPA terms and conditions that are identical to those terms and conditions that the commission approved for KELP. However, important disputes remain, and that's why we're here today. First, YELP and Northwestern disagree over the reasonable avoided cost price for capacity. Northwestern proposes a capacity payment that works out to about $3.23 per kW month. By contrast, YELP proposes a capacity payment of $27.56 per kW month. For comparison purposes, the Commission approved a capacity payment for KELP that was $25.14 per kW month. YELP's calculation presented in this case is pretty simple to explain. YELP took the calculations supported by the avoided cost capacity payment approved by the Commission for KELP and escalated those 5 years for inflation to reflect the fact that the KELP PPA was effective in 2024 and the proposed YELP PPA will be effective in 2029. Northwestern's proposed 87% reduction from the Commission-approved avoided capacity cost for KELP needs a little bit of unpacking. Northwestern estimates that the avoided capacity cost associated with the new 50 megawatt AERO, AERO natural gas-fired power plant is $20.62 per kW month. So let's talk about how they get from that $20.62 down to $3.23. First, the biggest issue that we have here is that Northwestern argues that its system has no need for any new capacity until 2040, and in 2040 has a need for only 4 months of the year, in 2041 has a need for only 6 months of the year, and in 2042 through 2048 only has a need in 9 months of each of those years. So Northwestern only assumes a capacity value in the months where Northwestern alleges there is a capacity deficit. And what they do is they take then all of those 73 months where they assume there is a capacity need, take the capacity cost that they estimate, and that creates a bucket of dollars. Northwestern then takes that bucket of dollars and develops a levelized payment over the entire 20 years of the contract, so that's how you end up with a capacity payment, which is, as Northwestern describes it, about $175,000 a month, or $3.23 per kW month. The evidence will show that Northwestern's assertion that it has sufficient electric generation capacity to serve its customers in Montana between now and 2040 is incorrect, and frankly, contrary to everything Northwestern says every time it is trying to justify investing ratepayer dollars on new Northwestern-owned generation facilities. Northwestern's 2023 IRP, which was filed just a few months before YELP's legally enforceable obligation, or LEO date, evaluated the existing and likely future resource acquisitions that would be able to serve Montana customers, including potential qualifying facilities, and determined, using the Western Resource Adequacy Program, WRAP, or RAP methodology, that Northwestern has a capacity deficit in 2029. The IRP base case scenario then goes on to assume that that capacity deficit will be met by a new natural gas-fired generation facility. Looking beyond the base case scenario in the IRP, other scenarios considered a situation where there could be an early retirement of Colstrip due to environmental limitations, and those scenarios forecast even more capacity need from 2028 to 2030, and that need will be met by a variety of resources, including potentially different natural gas plants, pump storage hydro plants, and batteries. Even though Northwestern's own IRP analysis in the RAP shows a capacity need, there's one other factor that needs to be considered. And that is Northwestern's analysis in the IRP, and as they will present to the Commission here in this hearing, assumes that Northwestern will be able to draw capacity as needed from other participants in the RAP. However, as we sit here today, that is entirely speculation. The RAP is currently in a non-binding phase, meaning that there is absolutely no guarantee that sufficient utilities will agree to commit sufficient capacity to allow Northwestern to rely on that capacity to serve Montana customers when the need arises. Prior to the time when ultimately we will create a potentially binding phase of the REP, utilities are not penalized if they fail to show that they do not have sufficient capacity to support the others in the program. The evidence will show in this case that as recently as last month, decision makers at the RAP agreed to move the transition period back in time to 2029, and further agreed to request that there create off-ramps to binding compliance if there are insufficient utilities in a particular region in RAP to create what RAP calls critical mass. For all these reasons, YELP encourages the Commission to continue to rely on the effective load carrying capacity, or ELCC methodology, to determine Northwestern's capacity need. The ELCC methodology looks only at Northwestern's resources that are committed within Northwestern and is designed to ensure that Northwestern on its own can meet Montana customers' needs. Given the razor's edge that we have been in on Montana in terms of having sufficient resources to meet customer loads and threats of brownouts or blackouts, until and unless the RAP is fully operational and clearly has binding participation sufficient to ensure that Northwestern can lean on its regional neighbors in times of need, it is critical that the Commission continue to ensure that Montana has access to the full amount of necessary, reliable fossil fuel-fired generation like the generation from YELP. Now, as YELP witness Mr. Gorman will explain, under the ELCC methodology, along with reasonable assumptions about other plants, including QFs coming online, and even assumptions that are recommended by Northwestern in terms of future QFs, Northwestern is clearly capacity deficit in 2029. Northwestern points out how Northwestern's capacity analysis also, in certain ways, inflates the amount of capacity available to serve load, including in its analysis several renewable resources, which Northwestern correctly concluded in its filing in early 2023 in the IRP were not going to come online, but which Northwestern claims should be considered even though final confirmation of the fact that those resources were never going to come online didn't occur until a month or two after the LEO date in this case. A further nuance within the debate over how the capacity cost is calculated is the notion that Northwestern argues that under the RAP methodology, capacity is only valued by the RAP in 9 out of the 12 months of the year. That means that even though costs are incurred year-round to ensure that there is adequate capacity available on demand as necessary to meet customer loads, Northwestern's analysis only includes a capacity value that goes into their levelized $3.23 for 9 of the 12 months in every year after from 2022 to 2039. As a result of that, the capacity payment to YELP is significantly understated. Consider, however, what happens if Northwestern were to build a capacity resource instead to serve customers. If Northwestern builds a power plant, the full costs of that plant are reflected in customer rates year-round, regardless of whether that plant is turned on for 1 day or 365 days. Northwestern's approach to how they derive the capacity avoided cost when compared to how they treat their own customers for plants that they owned is clearly mismatched. Northwestern's approach is even more inequitable when you consider the following. Northwestern's proposed PPA requires YELP to provide 55 average megawatts of capacity for each and every of the 240 months of the PPA, but only pays for that capacity in the 73 months where Northwestern alleges there is a capacity deficit. As a result, Northwestern's contract requires that YELP provide capacity for the remaining 167 months of the contract for free. Northwestern camouflaged this as a bit in the way that they designed their capacity payment rate. By taking the value of just those 73 months and then putting that into a bucket and levelizing a payment over all 240 months, it looks like they're paying for capacity all the time. But the reality is that the actual rate that is developed is assuming only that capacity is needed for that fraction of the contract, even though the obligation to provide the capacity is in each and every month. If the commission agrees with YELP that Northwestern has a capacity need over the entire life of the contract and that an avoided capacity cost payment is warranted, under Northwestern's analysis, the avoided capacity cost rate would go from $3.23 per kW month to $17.74 or $17.60 per kW month, depending on whether we're talking about the winter or the summer seasons. So that gap from 323 to 1774 in the price difference between the two parties is a function of the question of whether or not there is a capacity need during the contract. So how do you get from the $17 and change level to the $20.26 level, which Northwestern says is the actual cost of the plant? That $3 or so is a function of the issue that I will call, for purposes of this discussion, the net cone issue, or cost of new entry, CONE. Northwestern alleges in their calculation that the commission should reduce the capacity payment to reflect the ability of a natural gas power plant to make off-system market sales when it is not being used to serve Montana customers. Northwestern proposes what they call the net cone approach by taking the net of the costs of producing the energy less the revenues they gain from these off-system sales. But in Northwestern's proposal, they use those revenues not as an offset to the energy valuation of the contract, but rather as an offset to the capacity payment made under the contract. This approach was not approved by the commission in the YELP proceeding and has never been approved by the commission for a QF who has, as part of their contract, a per kW month capacity payment. Northwestern argues that this was approved for the QF1 rate, which is the standard rate the commission approves for small QFs, and so should be approved here. But that's an apples and oranges comparison, because the QF1 rate is a pure energy rate. It is not a rate that's split between energy and capacity. There is no per kW month payment under QF1. Now, this is important because, again, when you're looking at avoided costs, you have to consider how Northwestern operates when it owns a generator and its costs are passed through to customers. When Northwestern owns the generator, it treats revenues from off-system sales as an offset to the fuel cost of the plant, not as an offset to the capacity costs of the plant. Ratepayer rates are designed to collect the full capacity cost of the plant, regardless of whether that plant makes $0 in off-system sales or $1 million in off-system sales. All of those calculations under Northwestern's tariff and the commission's decisions, those only apply to the energy side of the equation. Well, that's important here because in this context, what is not happening is an energy rate that is derived as the difference between the cost of fuel less the cost of market purchases. That's the way Northwestern's retail rates are designed. That's not what's happening here. What's happening here is, as Northwestern has suggested and YELP has accepted, a market rate is being used for the energy payment. And that's important because a market rate already takes into account the supply and demand in the market, the costs of fuel versus the revenue opportunities associated with the sale of energy in market-based sales. And so by taking that market analysis, but pulling out of that these savings from off-system sales and using that as a deduction to the capacity payment, essentially Northwestern is double counting that in the analysis. Okay. I guess finally on that issue, I will note that the analysis ought to and should focus on how Northwestern acts as and how the proxy resources being used would act. But I will just note that it also is the case that under the proposed PPA, all of the energy and capacity produced by the project must be provided to Northwestern. And as a result, YELP has no ability to actually make market-based sales and actually generate any of that assumed revenue. All right, so that takes us from Northwestern's $3.23 to the cost that they estimate for the actual proxy resource, which is $20.62. So what is the last $7 of difference between Northwestern's 2062 and YELP's proposed 2756? That boils down to 4 different issues that you will hear during the course of this hearing. First, the single biggest component of that remaining approximately $7 gap is a question of whether or not natural gas power plant costs are increasing or decreasing over time. YELP, as I mentioned, takes the capacity costs that the commission approved for KELP and escalates those at about 2.5% a year between 2024 mid-year and 2029. Northwestern's approach does the opposite. Northwestern's approach takes their installed cost in 2024 and de-escalates that to have a lower cost for a new natural gas plant in 2029. The argument that Northwestern makes is that the natural gas power plant will be cheaper to build in 2029 than it is today. From YELP's perspective, that is contrary to recent experience, contrary to ordinary inflation factors. And we think that while there may be technologies like battery storage and solar, which have decreasing costs because of technological advancement, we think that the core technology in the natural gas power plants is not subject to those same sorts of factors, and instead will be subject to what is ordinary inflation for the steel and other components that go into a natural gas power plant. So we think de-escalating instead of escalating the costs makes no sense. Second, YELP's proposed cost include the cost of firm natural gas transmission systems or transportation systems to ensure that the generator can operate for extended periods of time, even during gas shortages or pipeline constraints that can and have occurred during significant winter storms. In contrast, Northwestern's assumed price does not include firm gas transmission service and only includes non-firm service with a short period of time of backup diesel. Third, YELP includes proposed operation and maintenance, or O&M costs, that include costs that Northwestern calls variable, but which are only variable insofar as they are different a little bit from year to year, not that they are variable based on how much energy the plant consumes. As such, YELP believes that the only variable cost that should be removed and assumed within the market rate assumption for the energy rate are variable costs that change based on the amount of energy that is produced. Just because a cost may be different from year to year does not mean that it is driven by changes in energy production. For example, some maintenance costs may only be incurred in every second, every third, or every fourth year of operation. So they vary from year to year. But those maintenance costs absolutely must be incurred in order to make sure that that plant is available to produce energy, regardless of the amount of energy that is produced in any one given year. YELP's approach is consistent with how Northwestern's retail rates are structured, where again, these sorts of costs are recovered through base rates and are not part of the fuel purchase power or other tracking systems. Finally, the fourth difference between that $20.62 and the $27.50 is the fact that we start with 2 different power plants. Northwestern proposes a hypothetical aero unit. YELP proposes essentially a hypothetical RICE unit, which is a reciprocal unit. That difference, it turns out, is a pretty small part of this equation. It turns out these other factors are a much more significant reason why these costs are different. But there is a little bit, couple bucks maybe, in terms of the difference between the power plants. Northwestern argues that the use of the aeroderivative unit is appropriate because the IRP says that the next unit, which is needed in 2029, will be an aero unit. I will point out here the irony of Northwestern's argument, because they use a unit in 2029, which they says isn't real because there's no capacity shortfall in 2029. Setting aside that dynamic, the problem that YELP has with using the aeroderivative unit is not necessarily the fact that it's an aero unit instead of a RICE unit. The problem is that that estimate is not based on a real power plant. It's based on hypothetical assumptions developed by a consulting group who is not here today to offer testimony to the commission, that is derived by estimates and projections from a variety of other utilities in their resource planning. By contrast, the data that YELP relies on is the actual data for an actual real power plant that is being built here in Montana, that being the costs associated with the Yellowstone plant. So that explains how you get those 6 different factors, the 2 big ones, the capacity need, the net cone, and the 4 smaller ones. That explains how you get to that difference between whether the capacity payment ought to be $3.23 or $27.56. That's the biggest issue in the case. And most of the testimony you hear will be about that point. But there are a few other points that I will highlight before I conclude here today. 1, Northwestern seeks to deviate from the commission's YELP decision and require that for this contract, the mechanical availability standard be calculated on a monthly, not a quarterly basis. The mechanical availability standard is a component of the contract that the commission approved in the YELP proceeding, which says that if the project is not 85% mechanically available, there is a penalty payment that is owed from the project to Northwestern. Importantly, that penalty is above and beyond the reduction in the capacity payment that occurs if the plant is not providing capacity as promised. Meaning, if the project provides less than the fully contracted capacity, the capacity payment is reduced. If that causes you to violate the 85% standard, there's another penalty that attaches. Because in a fossil fuel powered plant, maintenance can be a lengthy process, unlike the renewable plants that otherwise have these QF contracts. In the YELP decision, the commission agreed with YELP that that 85% capacity could be analyzed on a 3-month basis so that you don't double penalize the plant if in one of those months it has an extended outage for maintenance. Northwestern argues that that should not be the case and that there should be a penalty even in any month where you don't meet the mechanical availability, notwithstanding the different technology that's in play here. YELP asked the commission to order the same thing you did in YELP and be consistent. Secondly, Northwestern seeks to deviate from the YELP decision and require a maximum security deposit based on 3 years of capacity payments rather than the maximum security deposit being based on 1 year of capacity payments as was done in YELP. Ironically, Northwestern bases its notion that there should be a higher security deposit for YELP, 3 times higher, because there is a lesser capacity need for YELP as compared to YELP. Regardless, that's not the metric that should be used. The question for the security deposit is, will the plant operate as promised? YELP has been providing power to Northwestern and its customers for some 30 years. They've operated reliably and consistently. The evidence will show that Yelp has a very strong credit rating, and there is absolutely no need for Yelp to provide more security than the commission deemed was reasonable in the Kelp decision just recently. Last, but sort of not least, I guess maybe, there's an issue regarding the interconnection arrangements between Northwestern and Yelp. Relative to the interconnection issues, I'll start by noting at the onset that there is somewhat an unusual characteristic of the current effective PPA. That is that the PPA incorporates the terms of the interconnection arrangements as well as the terms associated with the sale of electricity and capacity. That's because the existing PPA was executed before modern interconnection rules went into effect and before the existence of the standard Large Generator Interconnection Agreement, or LGIA, and at a time when there was no pro forma agreement in place. So as a result, as we sit here today, the interconnection arrangements are embedded within the PPA, which will continue to operate until December 31st, 2028. Yelp proposes that the commission order the parties to enter into a standard LGIA. So Yelp acknowledges that the transition needs to occur from the old interconnection arrangements to the new interconnection arrangements, but asks that that take effect on January 1, 2029, along with the new PPA. Northwestern argues that the LGIA must be effective on signing. That means one of two things. That means either that Yelp and Northwestern have to agree to amend the existing PPA and replace the interconnection elements of that with the new interconnection arrangements, or that Yelp and Northwestern execute the new LGIA at midnight on December 31st, 2028, to ensure that there's no gap in the service being able to be provided. Neither approach is workable. As the Yelp witnesses, Mr. Bieber and Mr. Orndorff will explain, amending the interconnection arrangements now will result probably in Yelp being in breach of the agreement, because Yelp likely does not have the facilities in place to actually comply with the terms of the LGIA. This is for all the reasons that Mr. Powers for Northwestern explains, that there are things that the new LGIA requires that Yelp currently doesn't fully do. Secondly, one of the other issues about amending it right now is that the interconnection request that Yelp submitted requested interconnection rights for 57 megawatts. That's enough interconnection to do the PPA, but the reality is, and the evidence will show, that that was a bit of a mistake on Yelp's part. Should have asked for a little bit more. And the evidence will show that Yelp in the future will ask for a little bit more, and we'll see how that plays out. But in the meantime, 57 is at least enough to get started with the existing PPA, and that's fine. But currently, as I mentioned, the interconnection arrangements in place now don't have that limitation. And so Yelp has historically provided up to 62 megawatts of energy, in particular during the winter, when the facility is able to provide more energy than it can during the summer because of the way it interacts with the refinery where it sits. And so as a result of that, if we executed the LGIA now, and it had a limit of 57 megawatts, Yelp would be unable to sell all of the energy it currently is allowed to sell under the PPA for the remaining 4 terms of the contract. That economic loss is not good for Yelp, and frankly, it's not good for Northwestern customers who rely on Yelp now to meet the needs, in particular during those winter months. Yelp believes that it will need some time to engineer, procure, and install any necessary equipment to make sure it could comply with the LGIA. So you may ask yourself the question, well, why can't we just do that later then? Why do it now? And the issue with that is this. The LGIA is not a static thing. It can change periodically from time to time. What Yelp is concerned about is if we don't get the commission's authority to sign at least the 57 megawatt LGIA now, what happens if in 2027 or 2028, the terms of that LGIA a change requiring KELP to install something different, potentially, some different equipment to then meet those new obligations. I mean, nightmare scenario, December 15th, a new LGIA comes into existence 2 weeks before the contract is set to expire. It requires new equipment be installed. And on day one, YELP would be unable to comply with the PPA and be either in breach of that or in breach of the interconnection arrangements. So YELP is requesting that we lock into place what those provisions will be. We get that set up based on what is standard practice today, so that between now and January 1, 2029, YELP can make itself ready to fully comply with those agreements once they are in place. In conclusion, the witnesses that YELP will offer, Mr. Michael Gorman of Brubaker and Associates, Mr. Justin Bieber of Energy Strategies, and Mr. Owen Orndorfer, who is the president of Billings Generation, Inc., which is the general partner of YELP. Those witnesses will all show how YELP's position is fully consistent with and consciously and deliberately consistent with the Commission's recent decision in the KELP proceeding. Evidence will show that those decisions continue to make good sense, and there's no reason to depart from that precedent for this very similar power plant. YELP would like to continue to provide Montana with reasonably priced, highly reliable fossil fuel-fired generation that does not vary with wind or solar conditions, and we would like to be able to do that for years to come. We appreciate the Commission's time and attention to these critical points, and we urge the Commission to adopt the recommended PPA and interconnection terms that are consistent with Montana law and precedent as we recommend. Thank you.
Thank you, Mr. Chairman. Yes, we would. Are you ready for our pre-hearing statement?
Because I was errant by not having my microphone on, let me add the question again. Would Intervenor Northwest Energy like to make an opening statement at this time?
Yes, Mr. Chairman, thank you. Mr. Chairman and Commissioners, YELP's pre-filed testimony suggests that you should base your decision in this docket about YELP on the data and your decision in the KELP docket. Northwestern will show that the data that supported your KELP decision is too old to support your decision in this case. We will show that because by definition, avoided cost is an incremental cost, that cost changes when a utility updates its resource plan. And that's what happened between KELP and YELP. That's what happened between the KELP docket and this docket. In April of 2023, Northwestern filed its 2023 Integrated Resource Plan. In this case, to calculate rates for YELP, you will use the data from October 2023, the date of YELP's legally enforceable obligation that we call an LEO or a LEO. Northwestern and YELP don't dispute the date of the LEO. They don't dispute that date in October of 2023. Northwestern will show, however, that YELP even though YELP requested that you freeze time in October 2023 to calculate their rates, they're now asking you to approve rates based on information and data before that October 2023 date and after that October 2023 date. YELP proposed a capacity rate of $27.56 and Northwestern proposed $3.23. Northwestern will show that the difference in the proposed rates is largely due to the capacity contribution value assigned to resources in Northwestern's portfolio. That capacity contribution value is how much capacity Northwestern gets from resources that are already in its portfolio. A lower capacity contribution value results in higher capacity rates for YELP, and a higher capacity contribution value results in lower capacity rates for YELP. YELP and Northwestern do not disagree on the method for determining the capacity contribution value. Both parties present values based on the effective load carrying capability method, or the ELCC. That's not a contested issue because both parties present ELCC values in their documents. We'll explain that what is contested is whether to use the ELCC data from the 2019 plan or whether to use the ELCC data from the 2023 plan. Northwestern presents ELCC data that is tied to the FERC-approved tariff, and that tariff is not speculative. In addition, Northwestern will show that YELP proposes to get paid for energy twice. Once in the energy rate, which is a market rate, and they ask for a second time for a payment in the capacity rate. And they do this by adding the energy sales revenue in the capacity rates. This double counting will be presented to you as a gross cone method versus a net cone method. We will show you that the net cone method keeps the energy and capacity rates separate so that there is no double counting. Finally, Northwestern will show why you should approve its proposed PPA and its proposed terms for sections related to mechanical availability and default security. Again, this is not KELP. You have different data to base your decision on than the KELP docket. And the purpose of the provisions in the PPA is to protect customers because that's who are paying these rates. Customers are paying the rates for YELP's facility. In addition to a power purchase agreement, YELP has also proposed an interconnection agreement. For this agreement, YELP doesn't rely on old data. They rely on data that they admit is wrong. Northwestern will show that you should not approve the interconnection agreement because YELP admitted that it made a mistake by proposing an interconnection agreement based on studies for 57 megawatts. When YELP produces 62, not 57, YELP produces 62 megawatts on the Northwestern system. YELP asked you to require Northwestern to sign a legally enforceable contract that they know is wrong. Northwestern will also show why you should not excuse YELP from complying with the agreement once they sign it. No other generator, QF or non-QF, including KELP, on Northwestern system has ever been excused from complying with a signed interconnection agreement. Northwestern will show that YELP has not given you a reason to grant its request for a special excusal. For all these reasons, the Commission should approve the proposals that Northwestern presents in this case.
Thank you. Would intervener Montana Consumer Council like to make an opening statement?
No, thank you, Mr. Chairman. MCC waives opening.
Thank you. Mr. Nelson, you may now proceed with your case in chief. I would like at this point for all witnesses to please stand, raise your right hand, and I will swear you all in at once. Are all the witnesses for both parties, are they present?
All of our witnesses are present, Mr. Chairman.
Oh, and all the witnesses, okay. So do you swear that the testimony you are about to give is the truth and nothing but the truth? Thank you. Counsel? Okay, do you have any witnesses that are not present?
No, sir. They're all here.
Ms. Hill?
They're all here.
Very good. Okay. Mr. Nelson, you may proceed.
Thank you. We would call Mr. Michael Gorman to the stand.
Good morning.
Good morning, Mr. Gorman. Mr. Gorman, would you please state and spell your name for the record?
My name is Michael Gorman, Michael Gorman.
Mr. Gorman, by whom are you employed and in what capacity?
By Brubaker and Associates as managing principal.
And on whose behalf are you appearing today?
Yellowstone Energy Limited Partnership.
Mr. Gorman, in front of you in that notebook, just so you can take a quick look at that. In the very first tab there, do you see a document called Yellowstone Energy Limited Partnership's Petition to set terms and conditions for a qualifying small power production facility pursuant to Montana Code Annotated Section 69-3-603?
I do, yes.
And Mr. Gorman, you recognize that to be the document, the pleading that initiated the proceeding before the commission today?
I do.
And did you assist in the preparation of that filing, sir?
I did, yes.
And then past that, and possibly in your own records as well, do you see there the direct testimony exhibits of Mike Gorman? It's in the sort of second tab down there.
I do see that, yes.
And then, oh, sorry, with respect to the direct testimony of Michael Gorman, were those prepared by you or under your direction and supervision?
Yes.
Do you have any edits or corrections to make to your direct testimony at this time?
This reflects the errata we previously filed.
So, sorry, the errata we filed was to your rebuttal testimony, which we'll get to in a second.
There is a Leo date correction to the direct testimony.
Okay, let's make sure let's see if that's been fixed.
Yeah, I do not have any corrections to this testimony.
Okay. So, well, oh, I see what you may be looking at. Mr. Gorman, my able co-counsel here has flagged what I actually think is a problem now that I'm sitting here staring at this. If you look at page 2, line 20 of your direct testimony,
Yes,
do you have that in front of you?
I do, yes.
You see where it says Northwestern has agreed that YELP has established a LEO as of October 23rd, 2024.
Yeah, that is the incorrect date.
Right. Would it be correct to say that should be 2023?
In October 24th, yes.
Well,
Should-
for what it's worth, Mr. Chairman, I suppose maybe if I could just make a representation. So in YELP's documentation, we think that the LEO date is October 23rd. Northwestern's testimony says it's October 24th. This is a distinction without a difference. And so I don't think it's necessary for the witnesses to all correct that. Whether it's the 23rd or the 24th doesn't matter. But the application suggests that it's the 23rd.
I would note that the original statements were that there was no disagreement on the date of the LEO. It seems that there is. So can both parties agree on whether it's the 23rd or the 24th at this time for the record?
Pick a date.
The 23rd.
The-
23rd.
The parties agree that the Leo date is October 23rd, the year 2023. To the
Yes.
extent any pre-filed testimony says anything different, it's a typo and we don't need to fight about it.
Very good.
Thank you.
Agreed. Thank you, Ann. Okay. With that correction, if I asked you those questions under oath today, would your answers be the same, Mr. Gorman?
Yes.
And then lastly, I'll turn your attention a couple of tabs later to the second revised rebuttal testimony exhibits of Michael Gorman. Do you see that, sir?
Yes.
And was that testimony prepared under your direction and supervision?
It was, yes.
Do you have any corrections beyond those already reflected in the second revised document that was filed with the commission?
I do, yes. Comment on an answer I gave, which was based on a misunderstanding of a Northwestern spreadsheet dealing with the measurement of its capacity adequacy. Specifically, the Q&A is on page 17, starts on line 15 and concludes on page 18. In that Q&A, I respond to Northwestern witness, Mr. Sticer, in his claim that I did not include specific generation resources in my measurement of the resource adequacy of Northwestern. I responded that I did. All the resources at issue were listed on the Northwestern spreadsheet, but there was a toggle switch on it which limited the resources that were actually included in measuring the resource adequacy. I did not understand that aspect of the company spreadsheet at that time. So the answer to this question was not specifically correct. It was incorrect. However, correcting that spreadsheet to reflect the resources that Mr. Sticer states that should have been included in my exhibit MPG4 still shows that Northwestern will be capacity deficient in 2029 based on the standalone ELCC methodology. Specifically, on my exhibit MPG4, I showed a capacity deficiency of 368 megawatts in the winter. Of the resources identified by Mr. Sticer are about 338 megawatts. That still shows a capacity deficiency of around 30 megawatts in the winter of that year.
Excuse me, are we getting into testimony at this point rather than the correction?
So I think the answer to that, Mr. Chairman, is that we are explaining why the conclusions were the same, but the analysis is different, which I'm happy to do separately and independently from the corrections. So let me try this if I might, Mr. Chairman. So Mr. Gorman, am I understanding correctly from what you're saying that at the time you wrote this testimony, you analyzed this question differently than you would analyze it today, but your conclusions as stated are ultimately the same?
They are, yes.
Okay. We'll leave it at that for the moment and get into the potential differences otherwise. Okay. Okay. So, Mr. Gorman, I apologize. I can't recall if I asked you this question yet or not, but with the understanding we just discussed, if asked under oath today, would your answers in the second revised rebuttal testimony exhibits be the same as presented in that document?
Yes.
All right, Mr. Chairman, I would move the admission of YELP Exhibit 1, which is the application and supporting exhibits. YELP Exhibit 2, which is Mr. Gorman's direct testimony with the notation as to the Leo date, and YELP Exhibit 3, which is Mr. Gorman's second revised rebuttal testimony and exhibits.
No objection.
No objection.
Thank you. So they are admitted to the record. Thank you. Proceed.
Okay, Mr. Gorman is available for cross-examination.
Thank you, Mr. Chairman. Good morning, Mr. Gorman.
Good morning.
Are you all settled there?
I am, yes, thank you.
Mr. Gorman, you don't dispute that in the 2020 supplement to Northwestern's 2019 resource plan, Northwestern used a standalone ELCC method, correct?
The 2023, the 2020 supplement, that's correct, yes.
So you have read that 2020 supplement, correct?
Yes,
And didn't the 2020 supplement state that Northwestern retained the consulting firm Energy and Environmental Economics, known as E3, to calculate the standalone ELCC values?
I know they retained a firm to calculate those values. I would have to verify the name of the firm. I believe that's correct.
Okay. And switching to the 2023 resource plan, you've read that plan, correct?
Yes,
And you didn't find any reference in that resource plan to E3 calculating the ELCC values, did you?
I think in the 2023 plan, the company primarily switched to the RAP methodology, but
Okay,
included ELCC method, standalone ELCC method for illustrative purposes. And I don't recall whether or not they identified the consulting company that measured the UCC values of the resources under the standalone methodology.
okay. Could you refer to your Exhibit 4 and also use that laptop to pull it up on the screen since it's a Excel spreadsheet?
Have it?
Okay, this is a 2-page spreadsheet, correct?
Yes,
And page 1 is the title Standalone ELCC Capacity Accreditation Methodology for the Winter Seasons, correct?
yes,
And then page 2 is very similar. It's just the standalone ELCC methodology for the summer. Is that correct?
it is.
Okay. And if you could look, it doesn't matter which page, whether it's summer or winter, could you scroll down to show row 18?
I'm there.
Okay. And is it correct to say, well, row 18, it's identified as the capacity balance long or short, right?
Yes,
And it shows, you're showing negative values in parentheses. So that's showing that Northwestern's capacity portfolio is short, correct?
yes,
And then if you could refer back up to row 11, column E, and that highlighted cell says ELCC per E3, correct?
it does.
And that E3 is referring to Energy and Environmental Economics, the consulting firm, right?
I can't confirm that.
Isn't it true that you used a support file from the 2023 resource plan to create this Exhibit 4?
Yes,
And isn't it true that the file that you used to develop Exhibit 4 contained a disclaimer that a standalone ELCC values were no longer valid?
it stated that they were for illustrative purposes. So
Mr.
there was a disclaimer. I have to review the actual wording.
Mr. Chairman, if I could pull up the file just to refresh his memory. If I could take control and share my screen.
Please.
Okay. See how it is. I think I'm going to need help. So I have a file on my desktop. Need to actually go ahead and need to open. I should close on that. Thank you for your patience, Mr. Chairman and Mr. Chairman and Mr. Gorman. Let's see. Does this, what I'm pointing to right here look familiar?
It does, yes.
And that says the ELCC values on this tab have been superseded by RAP accreditations.
Yeah, that's my understanding of Northwestern's position, yes.
Okay.
Hmm.
Is it your position that the commission has not accepted Northwestern using RAP ELCCs?
Objection to the extent that calls for a legal conclusion.
If you could refer to your testimony, your rebuttal, well, it's in his testimony. I don't know how he handled the objection. I'll go to his rebuttal testimony and rephrase my question. If that works.
Please. Yes.
If you could go to your rebuttal testimony on page 6
There?
and line 2.
Yes. It's my understanding that the commission has not yet accepted the RAP methodology because the RAP is not yet in binding operations.
And you read the commission's comments on Northwestern's 2023 resource plan, didn't you?
Yes.
And isn't it true that in those comments, the commission required Northwestern to continue filing updated capacity forecasts with the commission using the RAP ELCC methodology?
The word I'm struggling with is ordered, but it's my understanding the commission directed you continue to work under the RAP methodology with the expectation at some point it will become binding.
Okay. Please turn to page 18, line 4 of your rebuttal.
I'm there.
Don't you state in your testimony that the ELCC analysis before the commission is the one that I have presented?
Standalone ELCC methodology is the one I've relied on, yes.
So those are the historical values from the 2019 plan that you relied on, correct?
They are from the spreadsheet the company filed in combination with its 2023 IRP.
So in your testimony, when you say the only ELCC analysis before the commission is the one I presented, do you dispute that Northwestern used ELCC values in its forecast?
Well, the effective load carrying capability is a term used to describe how the accredited capacity for intermittent resources is measured. From that standpoint, I don't dispute that Northwestern has relied on ELCC values. The distinction I'm trying to make is under the standalone method of measuring ELCC values, the accredited capacity reflects those resources being under the control of Northwest Energy and them not being able to rely on membership, the RAP membership to supplement those resources in the event they find themselves resource deficient. So it's a standalone method of estimating the ELCC values of their resources. And that's important because the ELCC values of Northwestern's resources under the standalone method are different than the ELCC method under the RAP regional methodology.
Thank you. That answers my question. In the KELP docket, you testified that to calculate the capacity rate, you should exclude the energy cost from the proxy resource because energy is already reflected in the avoided cost of energy, correct?
Can you repeat that, please?
So I'm referring to your testimony in the KELP docket, and I'm saying that you testified that to calculate the capacity rate, you should exclude the energy cost from the proxy resource because energy is already reflected in the avoided cost of energy.
Essentially, you separate the two in measuring the avoided cost of capacity and then a separate analysis to determine the avoided cost of energy.
Isn't it true that Northwestern's revenue from market sales is not representative of avoided cost?
It's not representative of avoided cost of capacity. It can be an estimate of avoided cost of energy.
Could you turn to page 29 of your rebuttal testimony?
There.
Do you dispute the general concept that the cost of installing new generation can decrease over time due to technological improvements and changes?
I do not, but I dispute whether or not that is consistent with the market expectation for the cost of installing new gas-fired generation.
Isn't part of your criticism of Mr. Steitzer's calculation of avoided cost based on your understanding that Mr. Steitzer projected a negative long-term trend based on a single year of 2021 to 2022?
Yes, I think that produced an escalation for the installed cost of gas to understate what the installed cost will be in the year 2029.
So if it were clarified to you that Mr. Steitzer did not project this long-term trend based on 1 year, that would change your testimony, correct?
Well, his numbers clearly show a decreasing installed cost.
Okay, conceptually, if he didn't base it on a single year of 2021 to 2022, would your criticism change?
It would not, because I'm aware of other independent sources that project the installed cost of natural gas resources. And there was a short-term period of a lull in the installed cost, but those same resources are now projecting positive escalators in the cost of installed gas starting around 23-24 timeframe. So the way I interpreted Mr. Steitzer's testimony reasonably aligns with what I'm seeing by other market participants concerning the cost of cone or cost of new entry, which generally aligns with market regional transmission organizations and the energy administration's projected installed cost of new gas-fired generation.
Thank you. Isn't it true that YELP is a 65 megawatt facility?
Its nameplate capacity is 65 megawatts. It uses some of that generation for internal operations.
And you agree with the opening statement with, so it produces 62, 64 megawatts. Is that correct? Like you're saying, it's 65 megawatts minus.
Yeah, it's actual historical operations over the historical operation of that varies the amount of capacity. Somewhere to my direct testimony for around 60 to 62 megawatts on average.
Okay, thank you. I have no further questions.
Thank you. Mr. Brown?
No questions. Thank you.
Thank you. Commissioner Fielder, any questions for this witness?
Thank you, Mr. Chairman. No questions at this time.
Thank you. Commissioner Pinocci, any questions for this witness? I note that we've had some communication technical problems with Commissioner Pinocci earlier, so he's not. Commissioner Bukacek, any questions?
No questions, Mr. Chairman.
Mr. Gorman, I'm have been interested in the RAP program for some time, and noting your statement that it is speculative to rely upon that at this time. Is there anywhere in the RAP program documents or projections, is there, do they provide any guarantee, any contractual guarantee to provide any shortcomings that Northwestern may experience?
The RAP, in
Yes.
terms of its operations, not that I'm aware of. Indeed, RAP's made announcements that it has not yet accomplished critical mass in getting members to make a binding commitment, a financial binding commitment to operate under the FERC tariff for the RAP program. Without that binding commitment, RAP members are not obligated to use surplus capacity to back up other members' capacity deficiency to improve the reliability of the region based on the expected operations of RAP.
Thank you. But what I'm interested in is the integrity of the RAP program itself, even when it reaches critical mass and has the mandatory, the binding status. And that is that if something happens on a regional basis, that would preclude participants from having any surplus energy to send to one of the other participants in there. Is that correct?
That is correct. And I think that's one hesitancy of many members making a binding commitment is they're unclear about the resources that are needed in order to meet the RAP obligations, the binding obligations.
Yeah, and so it would seem to me that there's a difference between a contractual obligation where somebody is required to provide electricity to something that may or may not be in a position to provide that electricity. So thank you. That's all the questions I have. Any recross at this point, or redirect, I should say? Let me start.
Redirect, yes, sir.
I wasn't reading my script. Pardon.
Okay. Couple of things that keep checking to make sure my microphone's on. All right. Mr. Gorman, a couple of questions to follow up on the cross-examination from Ms. Hill for Northwestern. First, you recall a discussion you had about the use of the ELCC methodology in your exhibit 4 as compared to what was done in the integrated resource plan?
Yes.
Okay. Now, if you'd like, I'm gonna, my co-counsel is gonna help Mr. Gorman find a document for just one moment. Okay. Mr. Gorman, I've had placed in front of you, do you see a discovery request which has been admitted into the record, which is numbered YELP question 009? Do you see that, sir?
But it was 11. Okay, yes, I have that in front of me.
Okay. That's just the page number. Ignore the page number. I'm looking at the number of the question. Okay. In response to that, can you do me a favor? Can you read for the record first question A, and then would you read Northwestern's answer to question A out loud for the commission?
Question A, please confirm this capacity deficiency was based on REP, resource adequacy QCC's requirement to not the internal ELCC methodology that NWE is used for resource adequacy determinations in prior IRP filings, including the 2019 and in part the 2023 filing. If Mr. Pellicore disagrees, please explain the answer. His response, confirm in part, deny in part. Confirm that Exhibit MMS3 measures Northwestern's capacity deficiencies based on RAP resource adequacy, QCCs. Deny that Northwestern modeled resource adequacy using the historical ELCCs in the 2023 IRP. All scenarios and sensitivities that were modeled in the 2023 IRP used RAP-based QCCs to determine the resource adequacy and the selections for Northwestern's portfolio.
Would you agree with me that to the extent there was an implication that the resource analysis in the 2023 IRP used the historical ELCC calculations, that's inconsistent with this discovery response, isn't it?
It's inconsistent with this discovery response and my reading of the 2023 IRP.
Okay. Could you please read question B and the first sentence in the answer?
Question, please identify the capacity deficiency under internal ELCC capacity sufficiency determinations for the same time period discussed by Mr. Pellicore in his testimony in the proposed term of the new PPA. Please provide all work papers and documents supporting those calculations. The answer, Northwestern has not performed this analysis.
Okay, so to the extent Northwestern had a concern with the calculation that you presented in your exhibit, in discovery, would you agree with me that YELP asked Northwestern to conduct the analysis as it saw fit using that internal ELCC capacity, right?
We did, yeah. We tried to eliminate any issues between us and the company concerning measurement of ELCC values based on the standalone or historical methodology.
And Northwestern declined to do so, didn't they?
Correct.
Mr. Chairman, permission to approach the witness and circulate a document to the witness, counsel, the commission?
Of course, thank you.
And could I just ask the court reporter if that could be marked as YELP Exhibit 7? Thank you. Mr. Gorman, I've placed in front of you a document that has been identified as YELP Exhibit 7. Do you see that, sir?
Yes.
Do you recognize this as a data request response that Northwestern submitted in the pending electric and gas rate case in Montana.
I do, yes.
And this is a data request response that you've had occasion to review.
Yes.
Move for the admission of YELP 7.
Objection, lack of foundation, lack of relevance.
I think a foundation has been fully laid as to what the document is, and that the witness knows what it is and has identified it. As to its relevance, I'm happy to talk about the substance of the document, which will, I think, illuminate its relevance. If Ms. Hill would prefer, I do that before it's admitted. I just wanted, having what I think laid a foundation, I wanted to admit it before we discussed the substance of it.
Mr. Gorman saying he's read this is not adequate foundation to admit a data request response from another docket from witnesses that are not in this docket. There is no adequate foundation for this exhibit.
It was in consultation. So the objection is overruled. Please proceed, Mr. Jones.
Mr. Gorman, in this data request response, do you recall that this discusses the budgeted estimates for the cost of the YCGS generating facility? Is that
Yes.
correct, sir?
Objection outside the scope of cross-examination. This is redirect, isn't it?
It's not, and I'll explain why in a moment. Let me start with that. That's a good point. Do you recall a discussion with council about whether or not the costs of natural gas facilities were increasing or decreasing over time, sir?
Yes.
Objection, I did not ask that question. I asked, if you want me to clarify, I asked whether he misunderstood Mr. Steitzer's testimony, whether Mr. Steitzer relied on 1 year of data or multiple years of data. It was limited to that.
Mr. Chairman, I think council opened the door to the issue of whether or not it is appropriate to have an escalator or not. In the course of Ms. Hill's cross-examination, she asked Mr. Gorman whether anything in her cross-examination would change his conclusions as to whether an escalator would be appropriate or not. And I think that that allows then an opportunity to redirect on the topic that she addressed.
Staff does believe that there was some discussion, as Mr. Nelson explained. And for that reason, the commission is inclined to overrule the objection.
Overruled. Mr. Nelson, proceed.
Okay. Mr. Gorman, so you see here that there was a question asked in here on exhibit YELP 7. In question C, it asked for the YCGS original budget. Do you see that, sir?
I do, yes.
And then in question D, it asks for the most current YCGS budget, correct?
Yes.
That original budget, is it your understanding that that was created at the time that the plant was approved by Northwestern Management?
It's my understanding, yes.
If you look at the second page of that document, in the tab that's, or in the table, excuse me, that's in the response to Part C, do you see where it shows the original estimated cost at the time that the plant was approved at $273,103,998?
I do see that.
And do you see where it says at the response to D, total cost has increased to $317,044,160?
Yes.
As a preliminary statement, how does that evidence here play into your conclusion that the costs of natural gas power plants are likely to increase over time as opposed to decrease over time?
This outlines other evidence I've looked at that the cost of installing a gas-fired unit is increasing over time, not decreasing.
Mr. Gorman, when you made your cost estimate using YCGS costs to develop a proxy cost for a resource to be used for avoided cost, what was the pre-escalation day one cost of your proxy resource, if you recall?
I believe it was around $286 million.
So your calculation of a proxy resource based on YCGS cost, based on this document, is actually less than YCGS actually will cost based on what Northwestern's reported here, correct?
Yes.
Permission to approach and circulate another document.
Yes.
Mr. Chairman, we'll ask the court reporter to identify this as YELP 8. If I could, the court reporter, did this get identified as YELP 8? Thank you. Mr. Gorman, I've placed in front of you what's been marked for identification as YELP Exhibit 8. Do you see that, sir?
I do.
And Mr. Gorman, do you recognize this document to be a document entitled Western Resource Adequacy Program, RAPC meeting dated August 29th, 2024?
Yes.
And do you understand the RAPC to be a committee within the RAP that is responsible for decision-making regarding how the RAP proceeds?
It's made up of the current and prospective members of RAP.
And if you look at the participants who participated in this meeting, do you see there near the bottom of the left-hand column of that table, one of the participants was for Northwestern, a Mr. Joe Steinmetz?
I do, yes.
Do you recall a series of discussions that you had with Ms. Hill regarding whether or not the RAP was something that was the impacts of it being in its binding versus non-binding stages and the degree to which the RAP is certain to occur? Do you recall that discussion?
I do, yes.
I move the admission of YELP Exhibit 8.
Objections?
I'm going to object again for lack of foundation. I don't know where this came from. I don't have, if we could just maybe provide a little more foundation.
Mr. Nelson.
Sure. Well, let me put it this way. Mr. Gorman, are you aware that RAP publishes its the public portions of its committee meetings on its website?
Yes,
Are you aware that this document was pulled from RAP's website and it reflects the minutes as reported by RAP of this August 29th, 2024 meeting?
that's correct.
I renew my motion for admission.
No objection.
No objection.
Thank you, Mr. Brown. Good to hear from you.
Okay.
So ordered.
Mr. Gorman, I'll turn your attention, please, to first, do you see on the table below the meeting objectives where it says meeting agenda?
Yes,
And I'll ask you to turn to the second page for the agenda that's identified at 9:10 in the morning, where it says revised transition plan. Do you see that?
I do. Yes,
Do you see there where it indicates that there was a discussion of a revision to the transition plan at the RAP, that it was the motion to adopt those changes was moved and seconded, and that the motion carried unanimously at 9:38 a.m. Do you see that, sir?
I do. Yes,
In the discussion you had with Ms. Hill, where you spoke of the fact that there were changes in the way that the RAP transition plan was going to work, is this what you had in mind in terms of the nature of those potential changes?
yeah. This document describes those changes.
Okay. Can I ask you now to turn to a couple pages later, and I apologize, the pages aren't consecutively numbered, but you'll see there is a proposal that's included that's called expedited proposal, about maybe 6 pages into the document, with a table. You see that, sir?
Yes,
Okay, so I want to just talk about, so first, in the first little tab there, it says revised transition plan element. And do you see where it says transition period definition?
yes,
Okay. And do you see it says existing policy from June 1st, 2025, summer 25 through March 15th, 2028, winter 27-28. Do you see that, sir?
I do. Yes,
Okay. And then in the next column, it says what the proposed policy is, which is to extend the transition period for an additional year through March 15th, 2029. Do you see that?
I do.
Objection. Mr. Chairman, the attorney is supposed to be doing direct testimony and he seems to be testifying. The witness is doing very little speaking. If you could ask YELP to please conduct direct examination where we hear more from the witness than from the attorney, that would be helpful. Thank you.
As it turns out, having identified him what I was asking about, I was just about to ask him a question. So, focused on that proposed change to the policy, Mr. Gorman, in your opinion, what are the implications of an extension of the transition period in terms of the degree to which this commission can reliably conclude that the RAP is for sure going to be in existence in 2029 and providing capacity to offset Northwestern's capacity needs?
The RAP, the financial commitments and the penalties for not complying with the FERC tariff rate will not be in effect until after the transition period is complete. That means the members of RAP are not obligated to provide surplus capacity to one another to ensure all members of RAP are able to serve their load reliably, or incur financial penalties if they fail to meet those RAP commitments. That time period where that financial commitment of all RAP members backing one another up has been extended into 2029. It may be extended again.
The next subject down on the table, do you see where it talks about a new definition of critical mass?
Yes.
I believe you used that term in your discussion with Ms. Hill. Can you talk about, from your understanding, what the significance might be, again, in terms of whether this commission can rely on RAP participation in terms of ensuring that Northwestern has the capacity it needs in the future, what's the significance of the idea that there will be this critical mass definition and the implications of that from your perspective?
The critical mass designates the number of memberships that need to make a binding commitment for RAP to be able to operate as intended. That is to have the pooled members that are making binding commitments use capacity resources to ensure that all RAP binding members are able to reliably serve their load. The critical is a standard which RAP needs a certain number of members to make that binding commitment, so it has a portfolio with adequate diversification in order to provide that surplus capacity back up across the region. So without a critical mass taking place, the RAP reliability objectives are, whether or not they can be achieved, are at question.
As you understand it, based on the fact that RAP is now creating this critical mass test or question, does that create uncertainty in your mind about whether or not, once we get into 2029, there will be sufficient participants in the RAP for Northwestern to be able to fully rely on them to back up Northwestern's needs in Montana?
Yes, I think the critical mass is uncertain at this point, and it's necessary to provide that capacity back up across the RAP members.
If I may have just one more moment. Thank you, Mr. Chairman, and that's all of the redirect questions I have. Thank you, Mr. Gorman.
Mr. Gorman, thank you for your participation. You were temporarily excused.
Thank you very much. I appreciate it.
Noting the time is 10:51, we'll take a 15-minute break. We'll reconvene in 15 minutes. Thank you. Okay, let's get back on the record. Mr. Nelson, you have a next witness?
Yes, thank you, Mr. Chairman. YELP would call Mr. Justin Bieber to the stand, please.
I would note that he looks different from his publicity.
Mr. Bieber, you were present when the witnesses were sworn, is that correct?
Yes, that's correct.
Would you please state and spell your name for the record?
Yes, it's Justin Bieber. That's JUSTINBIEBER.
And Mr. Bieber, by whom are you employed and in what capacity?
I'm a principal for energy strategies
And on whose behalf are you testifying today?
on behalf of YELP.
Mr. Bieber, in the book in front of you, if you need to refer it, but you may also have a copy. Do you recall causing to be filed the direct testimony and exhibits in this proceeding?
Yes, I do.
And do you have any changes or corrections to your direct testimony at this time?
No, I do not.
If I were to ask you the questions contained in that testimony under oath today, would your answers be the same?
Yes, they would.
Mr. Bieber, do you also recall preparing or causing to be prepared rebuttal testimony and exhibits in this proceeding?
Yes, I do.
And those were prepared by you under your direction and supervision?
Yes, that is correct.
If I were to ask you the questions contained therein today under oath, would your answers be the same?
Yes, they would.
Mr. Chairman, I'd move the admission of Exhibit YELP 4, Mr. Bieber's direct testimony, and Exhibit YELP 5, Mr. Bieber's rebuttal testimony.
No objection.
No objection.
Thank you. So admitted.
And I forgot to ask, I think I know the answer, but you had no corrections to either of those pieces of testimony, is that correct?
That's correct.
Mr. Chairman, the witness is available for cross-examination.
Thank you, Mr. Chairman. I have no questions.
Um,
No
Mr.
questions, Mr. Chairman.
No questions. Vice President Fielder, any questions for this witness?
No, thank you, Mr. Chairman.
And Commissioner Pinocci? Apparently, we're still having those technical problems. Commissioner Bukacek?
No questions, Mr. Chairman.
And I have none. Commissioner Attorney, Ms. Webster?
No questions.
It seems silly to have a redirect.
I think by definition, Mr. Chairman, we have no redirect.
All right, not being an attorney myself, I'm not familiar with exactly that. So, Mr. Bieber, that I think that does you as a witness. I think so. Everything has been admitted. Is that correct?
That's correct.
Yes. So you may be temporarily excused.
Thank you.
Thank you. Wow, you get a reward for your celerity.
Next, YELP would call Mr. Owen Orndorff to the stand. It's entirely up to you.
Yes, understandable.
Great. Mr. Orndorff, were you present in the room previously to be sworn?
Yes, I was.
Would you please state and spell your name for the record?
Owen H. Orndorff. Owen, O-W-E-N. H is in Harvey, and Orndorff is O-R-N-D-O-R-F-F. YELP.
If I could ask, are you able to hear him okay? Is his volume all right? Yeah, or maybe move the microphone a little bit closer.
Certainly.
Thank you. Mr. Orndorff, by whom are you employed and in what capacity?
I am president of Billings Generation, which is the general partner of YELP.
And on whose behalf are you appearing today?
YELP.
And did you cause to be filed in this proceeding rebuttal testimony and exhibits?
Yes,
And were those prepared by you or under your direction and supervision?
yes,
As you sit here today under oath, would your answers contained in that rebuttal testimony be the same?
no,
And, oh, that's right, you have a correction. I apologize. I should have said that first. Do you have any corrections to your testimony, sir?
I believe on page 8 of my rebuttal testimony on line, is it 27, 28? The word 10 should be 2.
Yep. Oh, slow down just a second. So it's page 8, sir?
I believe so. 8 of 10. Oh, sure it is at the bottom of the page.
I think it's actually page 6 of 8.
Oh, is it 6? Okay.
Okay. So let's go more slowly here. Page 6 of 8. You can see that. And am I correct that you were directing us, if you look at your document there, to line 30 on page 6 of 8?
What did you give me? On 6 of 8.
Look at line 30 there at the very bottom.
Something happened to our transcription of the pages.
Can I approach the witness?
I do better with my other draft. Where are we done, Tor? Oh, yes, it is on line 30. Thor is correct.
Okay.
The word 10, which is in 5 or 6 words on line 30, should be 2.
Okay, and again, I apologize. If you could just make sure you speak up into the microphone. So on line 30, the word 10 should be replaced with the word 2. Is that
Yes,
correct?
that's correct.
Mr. Chairman, if it's agreeable to the commission, I had a discussion with commission counsel and counsel for Northwestern earlier. And since we don't really keep physical copies of the testimony where the witness marks them out and relabels, I would ask permission to file an errata sheet with that change reflected for the commission's files, if that would be acceptable.
No objection.
I believe that. Thank you.
Okay. So we'll get that on file. And thank you, Mr. Orndorff, for flagging that. With that correction, if I asked you the questions contained in your rebuttal testimony today, would your answers be the same?
Yes, they would.
Thank you. I'd move for the admission of the corrected rebuttal testimony as YELP Exhibit 6, please.
Objections?
No objection.
No objection.
Thank you. So,
Thank you, Mr. Chairman. The witness is available for cross-examination and questions from the commission.
Ms. Hill?
Thank you, Mr. Chairman. Good morning, Mr. Orndorff.
Good morning.
It's your intention, correct, to continue operating the YELP facility over the term of this 20-year PPA as the facility has been operated for the past nearly 30 years, correct?
That is correct. And obviously times have changed, and we will, starting in January 29, obviously adjust the interconnect, the LGIA, to the standard that is then in place in 29 versus when we originally signed the PPA in 1990. That's probably the only change that will occur that I know of today.
Thank you. I have no further questions.
Mr. Brown,
No questions. Thank you.
Commissioner Fielder, any questions?
No, thank you.
Commissioner Pinocci? Still not with us. Commissioner Bukacek?
No questions, Mr. Chairman.
I do have a question on the very next page from the one that was cited. In line 9. Mr. Powers asserted that YELP, quote, has not provided reactive power support and voltage control to help maintain reliable operation of the interconnection as required by Article 9.6.2 of the LGIA. Could I ask which LGIA? Is that the one currently in effect, or the proposed one?
Mr. Chairman, we do not have an LGIA today, as was previously testified to. It's part of the PPA that was signed in 1990 and is embodied, as I've in my testimony have explained, in all of the loan agreements and through December 31st, 2028. The LGIA would come into be effective January 1, 29, and we are obviously not complying with an agreement that doesn't exist.
Yes, thank you. One other question, again, has not provided reactive power support and voltage control to help maintain reliable operation of the interconnection. I think in your testimony, you point out that you stress several times under the current agreement that you have that you're consistent. But so the impression I've gotten from this is that Northwestern has asked you to comply with some of the current operational standards that you have not gone along with because they're not required. As far as you know, has any lack of putting these new standards in, has it affected in any material way the use of Northwestern's use of power from you? Has it really caused any problems?
We know of no problems that it's caused, but let me just, if I could, amplify a little bit on why we are where we are. As part of the power sales agreement, we have Appendix B, which is the interconnect portion of the power sales agreement. That interconnect Appendix B has a list of equipment which we are required to install. We did install. We pay $9,000 some a year for maintaining it, insuring it, the property taxes, and there is no provision for changing that equipment. And that equipment, by definition, does not satisfy the requests that Northwestern is making in 2024 for reactive power. And it would require a rebuild of the interconnect as it is today. And there's no provision for us to do that. And besides that, it gets all muddled up in our loan agreement, amending the loan agreement, and the lenders getting involved in defaulting us. This agreement, everybody is counting on to last until January 1, 2029. And at which time, with a little planning in advance, like a year or two or more, we will have rebuilt it and we will be effective with the LGIA that is in existence on the date we sign the contract. I don't, if you were a project just starting up, you would obviously be connected on the first commercial day of operations or sooner. This is just what an existing project has to do.
Thank you. I'm not asking in any way for a legal opinion on this, but what is your understanding of the apparent disparity between having a new PPA to go into effect on 1/1/29, but to have a portion of that agreement taken effect today. I don't understand how you can have bifurcated, is that a decent word? Requirements.
Well, I guess what we're suggesting is that the agreement to start a new terms and conditions in 29 can get signed now, but is not effective until 29. As far as the LGIA goes, we can't change anything until after the PPA or the loan agreement expires. And we've got a 2-year window to hire the engineers and to work with Northwestern and get the LGIA in place versus the old regime that is in the power sales agreement, and move forward with the where we are as of 2024. The technology constantly is developing and new requirements come in, and you've got to build it for an effective date, and FERC understands all this, and that's why we were grandfathered under the old contract. So we're going to have a state-of-the-art LGIA in 29, but we will have an effective agreement in 24, looking out into the future to make that happen.
Thank you. One last question on that, and that would be if this commission agreed with Northwestern to have the LGIA come into effect upon signing and not later, then assuming the company's contention that they would therefore possibly not be in compliance, if they were not compliant, what do you think, in your opinion, would Northwestern do in respect of that non-compliance?
I suspect that their desire would be to shut the project down, like they've tried several times.
Thank you. Ms. Webster?
Staff has no questions.
So this would,
Do I get redirect this time, Mr.
yes, oh,
Chairman?
absolutely. Yeah. Well, recross, right?
Okay, I have a question.
Sure. Go for it.
Mr. Orndorff, isn't it true then to comply with the January 1, 2029 interconnection agreement that YELP proposed in this docket? You do have to change your operations to reduce your output to 57 megawatts.
Well, on paper, that is what it shows, because we had an engineer make a mistake. He's not here in the room. He was a consultant, and he got confused between the actual production of the project for 35 years and the nameplate average capacity. These things happen in the power business, and when you have a mistake like this, you have to correct it. So what we need to do is to get the direction to go forward with 57, just like with the interconnect. We need to move forward and get a new study done for what we've proving what we've done for 30 years, which, just like in YELP, shouldn't be that hard to do. And along the way, get the new interconnect built.
But you, in this docket, you're asking the commission to require Northwestern to sign an agreement for 57 megawatts that you may not comply with because you're hoping to make changes, right?
Yeah, to reflect the past, or the way the plant has been operated in the past. And that's what I testified to. We intend to operate the plant just like it has been in the past, a reliable producer of capacity and energy. And we had an engineering mistake. These things happen. And we will file a new study and work in the next 4 years or so to get the interconnect so that it is matches what we've had for the last period of time. Now, all of this sizing was worked out in 1992 with Montana Power and agreed upon. And we just had an engineering mistake that we need to go back and fix.
Thank you. No more questions.
Okay, a couple of questions. So first question, Mr. Orndorff. Relative to the LGIA issue that was addressed by both commissioner questions and questions from Northwestern's counsel. If the commission agrees with YELP and requires the execution of the LGIA at the 57 megawatt level, and if it turns out, for whatever reason, there is a delay in Northwestern's ability to study and agree to expand that to a higher level, on January 1st, 2029, is it YELP's intention to fully comply with whatever the applicable LGA terms are?
Of course, that's the only thing we can do. If it's smaller, the consequences are obvious to the ratepayer, and they'll just have less power.
Okay. So if it is necessary to comply with the LGIA, is it fair to say that YELP will change the way it has historically operated in order to comply with the agreement?
If that's the pleasure of this commission and Northwestern, then of course we'll do that.
Okay. In your conversations with Northwestern, has Northwestern ever, let me put it this way. Is it your understanding that there is a risk, given the way that the interconnection queues and study processes are working, that Northwestern may be delayed in studying a future request to increase the interconnection from 57 megawatts to 65, for example?
Well, I know of no risk right now. I do know that we've been operating this way for 30 years. And until we offered to extend the contract, this has never been an issue.
I got it. But if it were, here's what I'm trying to get, Mr. Orndorff. Northwestern says, let's just delay and do this later. But before that happens, isn't it true that there would need to be a study about the additional capacity request from 57 megawatts to the higher number, right?
My understanding is that we need a study done to raise the interconnect request.
Okay. Is it your understanding that Northwestern has or would commit to you today to do that study on any particular time frame?
I know of no time frame. Everything has gotten kind of tied up with this hearing.
Okay. So are you concerned that if there is a delay in that study, that putting off to some point in the future the decision about executing on the 57 megawatts could put YELP's ability to actually deliver power on January 1, 2029 in jeopardy?
No, we would just go with 57 and a smaller project, just like I said.
No, okay, let me try this again. Let's assume that Northwestern's proposal is granted and they do not sign the 57 megawatts.
Oh,
We have no interconnection agreement until some point in the future when some future study is done, which currently has no timeline.
oh, well,
If there's no interconnection study that's agreed to, is there a concern that on January 1, 2029, we would not be able to deliver power?
Objection again, the attorney's testifying.
I misunderstood the question.
Hold on, Mr. Rodolph, there's an objection.
So as I understand, the objection is that it was luminous in nature and actually took the form of testimony rather than of a question. So would you rephrase the question?
Okay. Mr. Orndorff, if you know, and if you don't know and you want to refer to another witness, now's your chance. If you know, what is wrong from YELP's perspective with Northwestern's proposal that there be no interconnection agreement at all that is ordered by the commission today in this hearing?
We wouldn't be able to operate the plant on January 1 if there's no interconnection agreement. I got confused between PPA and interconnection. You have to have both in place to have a viable project. And if Northwestern won't sign the interconnect agreement for the project, then there's no project and there's zero power, and the project ceases to operate.
And as you understand it, if a future request is made to increase the study from 57 to 65 megawatts, as you understand it, that study has no time limit from Northwestern's perspective, and they can take as long as they want to do that study, right?
That's my understanding, and we would then still have 57. That was the question I was trying to answer.
But we only have 57 if the commission orders Northwestern to sign it, right?
Correct.
Because Northwestern has said they won't sign 57 on their own devices, right?
That's my understanding.
Objection.
Okay.
I think you're running far afield.
All right.
So, any more cross-examination of this witness?
Redirect.
Any more
I thought
testimony?
that was redirect.
I think I have neither cross-examination nor redirect. Thank you,
Okay,
Mr. Chairman.
Yes. So you are temporarily excused, sir.
Thank you, Mr. Chairman.
Mr. Nelson, any further witnesses?
So, Mr. Chairman and Counsel for Northwestern, I will offer this, and I leave it up to your collective desire. Based on what I think is some potential confusion from the testimony that was just elicited from Mr. Orndorff, we will be calling as a live rebuttal witness, Mr. Bieber, who actually is the interconnection expert in the case, to address these issues that have been raised. In the ordinary course of business, we would call our live rebuttal witnesses sort of after the hearing. I just make a note now that in light of the elicited questions and answers from the commission in particular, if it would please the parties, I'm happy to do that now. Or we can do that at the conclusion of Northwestern's case, but I wanted to just alert everyone to that possibility and do whatever's in the commission's pleasure, subject to Northwestern's agreement one way or the other.
Well, prior to deciding that, do you have any further witnesses?
Well, that's what I was about to say.
No, any additional other than Mr. Bieber?
Other than recalling Mr. Bieber, I have no other witnesses at this time. I'm happy to recall Mr. Bieber now, again, if that's the commission's pleasure, or we could do that subsequently.
Ms. Hill?
Northwestern objects. Live rebuttal contemplates that he's rebutting something that Northwestern said on the stand. Northwestern hasn't even testified yet. So he is not contemplating live rebuttal. What he is proposing is a mechanism to get Mr. Bieber on the stand, to get Mr. Bieber talking when I didn't have any cross for Mr. Bieber, and he's trying to undermine that. And you should not allow him to do it.
Fair enough. We'll call Mr. Bieber later if appropriate.
I think that's reasonable.
Then no further witness at this time. Thank you.
Okay. Being that it is 11:36, and we're going to take a break for lunch, should we just take a break now?
I think that makes sense.
Okay, so we'll reconvene at 1 o'clock, and we're off the record.
people's. With it.
Okay, it is now 1 o'clock. We are back on the record. I think where we left off is Northwestern's opportunity to present case in chief. All their witnesses.
Yes, thank you, Mr. Chairman. Northwestern calls Mr. Damon Palacore. And he's already been sworn in, so if you're okay, once he gets settled, we'll get right into the questions. Good afternoon, Mr. Palacore. Could you state your name and business address for the record, and please spell your name for the court reporter?
Sure. Damon Palacore, Damon, it's middle initial, Pellicori. Business address is 208 North Montana Avenue here in Helena.
By whom are you employed?
Northwestern Energy.
And what is your title with Northwestern?
I'm an energy supply analyst.
Did you submit pre-filed testimony in this docket?
I did.
And do you have that testimony before you?
I do.
And is that the intervener testimony of Damon Palacore?
It is.
Do you have any corrections to your testimony?
I do not.
If I were to ask you the same questions here today, would your responses be the same?
They would be.
Mr. Chairman, I move to admit Mr. Palacore's intervener testimony as Exhibit NWE1.
Any objections?
No objection.
No objection.
Thank you.
No objection.
Mr. Chairman, I tender this witness for cross-examination.
Good afternoon, Mr. Palacore.
Good afternoon.
My name is Thor Nelson. I'm an attorney for YELP in this proceeding. Do have a couple of questions for you. And of course, my computer has gone to sleep, so hold on. Give me just one moment, please. Okay. If I could you please start by, you have your testimony there in front of you, sir?
Yes.
Okay. I want to start with some of the issues you raise regarding the proposed PPA terms and those issues that still remain in dispute about that. Hold on just a second. Okay. And I'll call your attention first to page 4 of your testimony, and in particular, line 12. And let me know when you're there.
I'm there.
There you have a question and answer that opens a discussion regarding your objection to YELP's use of a calendar quarter calculation to determine if the generator meets the mechanical availability requirement. Is that fair?
It is.
On page 4, line 23, you see where you use the word damages.
I do.
Okay. Can I ask you to now turn to your exhibit DAP1?
Any particular area?
Page 13, please.
Okay. Okay.
Now, just want you to have those two things handy as we talk through this. So at page 13, do you see there near the top of the page, section 5.4, which is the mechanical availability guarantee?
We might have a difference in numbering, but I can certainly go to section 5.4.
So it's DAP1, page 13 of 36, I think, in the red line.
There we go. I was looking at the bottom numbers. Okay.
Oh, I apologize. The pagination at the top. Thank you.
Got it.
All right. So 5.4 is the mechanical availability guarantee. Do you see that, sir?
I do.
And this is the portion of the contract which uses the concept of a calendar quarter versus your proposed calendar month. Is that fair?
Yes.
All right. So keeping that handy, I want to go back to your testimony, and we're going to talk about both of those a little bit. So if you look at page 4 of your testimony, at line 21, you say, in the quarterly example, the QF could underperform significantly in a specific month, yet not be subject to any damages if the other 2 months increase the quarter's total to the threshold. Do you see that, sir?
I do.
Okay. So when you use the word damages there, you are specifically referring to the penalty provision in section 5.4 of the contract, correct?
I am.
You would agree with me that if YELP in a particular month provides less capacity than is required by the contract, either 51 megawatts or 57 megawatts, depending on the month, that the capacity payment is reduced to the amount of capacity actually provided, independent of whether there is a further penalty payment under section 5.4, correct?
Do you mind repeating that?
Sure.
Okay.
You would agree with me that if YELP underperforms in a specific month, causing it to deliver on-peak capacity below the contractual requirements, that the monthly capacity payment is reduced in the contract based on that underperformance, separate and apart from whether there is a further penalty payment under section 5.4, correct?
The mechanical availability, as I've proposed as a monthly standard, would pay less if the plant underperformed. Okay.
Okay, let me start over because maybe you're not getting me.
Sure.
My point is this. If the plant doesn't provide the proposed capacity, regardless of the mechanical availability standard, the capacity payment is reduced, correct?
That is correct.
Okay. Then the mechanical availability standard adds another potential penalty on top of the reduced capacity payment if they fail to meet the 85% threshold, correct?
It does.
Okay. So when you say, and here's what my point is, when you say YELP could underperform yet not be subject to any damages, Yelp would be subject to a reduced capacity payment in the month where they underperformed, even if the quarterly standard was used in the mechanical availability standard, correct?
That is true under Exhibit D.
Okay.
Yes.
And further, in that month where they underperformed, Yelp would experience a reduced amount of energy payments, presumably under the contract, correct?
Conceivably, yes.
Okay. Can I have the permission to approach and circulate some documents? Austin, I want to do the executed PPA, the final order. And Yep, you. That'll be 9, that's 10, that's 4. Which word? Okay. Okay. Just for the record, first, I'll just flag that the document called Qualifying Facility Power Purchase Agreement, I've asked that that be marked for identification as YELP 9. The document labeled Final Order 7859I, I've asked to be marked for identification as YELP 10. And the document labeled Orders 7859K on reconsideration, I've asked to be marked for identification as YELP 11. Mr. Pellicoria, are those numbers noted on the versions that we handed you?
No.
Okay, Austin, can you please go fix that? 9, 10, and 11. Just to make sure you can keep track of, oh, here, take mine. Here, and give them those.
All right.
Okay, Mr. Pellicoria, first document I'd like to ask you about is what's been marked for identification as YELP Exhibit 9. Do you see where it says there, qualifying facility power purchase agreement between Northwestern Corporation, DBA Northwestern Energy, and Colstrip Energy Limited Partnership? Do you see that, sir?
I do.
And do you see up at the upper right corner of this document, there's a little note there which says execution version.
I see that. Yep.
And if you go to page 26 of the document before you get to the exhibits, and let me know when you're there.
Oh,
It should be the signature page.
okay. I'm there.
You see that there are signatures for Mr. Byrd and Mr. Orndorff there.
Yep. I see that.
Do you understand this to be the executed version of the PPA between Northwestern Energy and KELP?
I do.
I'd move for the admission of YELP Exhibit 9.
No objection.
The next document I'll ask you to take a look at is the one.
Mr. Brown,
Oh, sorry.
are you with us?
Yes, thank you, Mr. Chairman.
No
Okay.
objections?
No objection.
Thank you. So admitted.
Thank you. The next document I'll ask you to take a look at, Mr. Pellicori, is what's been marked for identification as YELP 10. And do you see that as a decision of the Public Service Commission, as noted in the top there in docket number 2022.07.073?
I do.
You see that's labeled Final Order 7859I.
Yes, I see that.
And maybe I'm going backwards here, but do you understand that to be a decision in that docket which related to the KELP?
That's my understanding.
Move for the admission of YELP 10 by administrative notice.
No objection.
No objection.
So admitted.
YELP 11, sir, if you could now turn to that. You see that that is Order 7859K on reconsideration in the same docket, the KELP proceeding.
Yes.
I move for the exhibit of YELP 11 by administrative notice.
No objection.
No objection.
Thank you. So admitted.
All right. Mr. Pellicoria, if I could ask you to take a look, please, first at what's been admitted as YELP Exhibit 9, which is the PPA. Would you agree with me that in section 5.4, which you can find on page 9 as numbered at the bottom, there is a mechanical availability guarantee provision in this contract?
Yes.
Would you agree with me that that provision calculates the mechanical availability on a calendar quarter basis?
I do.
Okay, would you please take a look at YELP Exhibit 10? And in particular, again, at the page numbers on the bottom, page 31 of 37.
Okay.
You see there a paragraph 90.
Yes.
Do you see there sort of that, do you see that that paragraph on the label refers to the mechanical availability guarantee?
Yes.
And looking at the bottom, do you see where the commission says that the commission finds that section 5.4 ensures Northwestern of KELP's ability to generate energy. Commission finds the inclusion of this provision provides a guarantee to Northwestern of KELP's energy production ability. The commission finds that inclusion of section 5.4 is appropriate in the PPA.
Yes, I see that.
Can you please now take a look at YELP 11?
Yep.
In particular, I'll call your attention to page 18 of 21 of that document.
Okay.
On page 18, do you see a paragraph 52 there?
I do.
Do you see there that it says, the commission also finds that measuring outages on a quarterly basis is appropriate. Coal-fueled facility maintenance outages are different and longer than renewable facilities. To recognize the difference in resource type and to allow KELP to have a reasonable opportunity to comply with the mechanical availability requirements in the PPA, the commission finds KELP's request to measure outages on a quarterly basis a reasonable outcome. Do you see that, sir?
I do.
Would you agree with me that the mechanical availability provision of the YELP contract that YELP proposes is identical to the version of the KELP contract approved by the commission?
Yes, YELP's proposal is identical to the KELP.
Okay. Let's talk about security deposits. YELP proposed a security deposit requirement that was based on a determination of creditworthiness by Northwestern, but would not exceed 1 year of capacity payments. Is that correct?
That's correct.
Northwestern's recommended security deposit would again be based on a determination of creditworthiness by Northwestern, but would not exceed 3 years of capacity payments, correct?
That's correct.
If you look at the YELP proposed level of capacity payments, would you agree with me that under YELP's proposed security deposit requirement, that deposit requirement would be $760,225, correct?
Are you looking at a specific page at this point?
Well, so we can if you'd like. If
Okay.
you look at your testimony and the DAP 1
Yep.
and the security deposit provision, I apologize, I don't recall which page that's on.
Yeah, no, I can find it. I was just
But if you
checking.
find that, you should find a red line strikeout of that number.
Okay, I'm there.
Do you see there where you struck out the figure 18 million? Oops, sorry, I lost it. $18,760,225.
Yes, I do.
Okay. Now, if that's the calculation for 1 year, a 3-year calculation would be 3 times that number. Fair?
Fair.
Okay. Now, of course, whether you do 1 year or 3 year, that would be a lower number if you accept the capacity payment that Northwestern is proposing, right?
That is true. Under the 323 value.
Right.
Yes.
Okay. Can we go back to the YELP 11 for a moment, please? Do you have that in front of you, sir?
I do.
Okay. If you could look at, just to orient yourself, on page 19, there's a paragraph number that starts 57. Do you see that?
Yes.
And then that paragraph 57 continues over the top of page 20.
Mhm.
Okay. And the language at page 20 is what I want to call your attention to.
Okay.
Do you see where it says, the purpose of security at this point is to ensure that Northwestern is able to secure capacity if KELP defaults on its new obligations.
I see that.
Furthermore, nothing guarantees that KELP will even have to pay security. As defined in section 7.1, KELP can demonstrate its creditworthiness to avoid the additional security requirement. You see that?
Yes.
Then skipping the site, Commission goes on to say the commission concludes that it is commercially reasonable for Northwestern to have the discretion to determine whether the security requirement is excused by KELP's creditworthiness. You see that?
I do.
And then it concludes, the commission affirms its decision to include section 7.1. Article 7 must be included in the PPA, and Northwestern may modify section 7.1 to reflect a full year's capacity payment based on the avoided cost of capacity, correct?
That's correct.
Would you agree with me that YELP has been in operation since 1995?
I believe so, yes.
Would you agree with me that you have not identified anything in your testimony about anything in that 30-year history of operation that you cite in support of justifying a maximum security deposit based on 3 rather than 1 year of capacity payments, correct?
That's correct, not in the history, but under the different circumstances of this PPA, there are some differences here.
But there's nothing in the history which suggests that the YELP will default on its new obligations, correct?
I'm not aware of anything in the history.
There's nothing about YELP's creditworthiness that you cite in support of an argument that YELP's security deposit should be 3 times higher than the commission ordered in KELP, correct?
I do not cite anything related to creditworthiness, but nor have I looked into it. That'd be something that would be much closer to the signing of a PPA.
Okay. Your argument, as I understand it, is that the higher security deposit is warranted in this instance because of the number of years that Northwestern proposes that there is no capacity requirement. Is that fair?
That is correct.
Okay. If the commission disagrees with you and concludes that there is in fact a capacity requirement in every year of the contract, that would resolve the concern that you have, correct?
That's a fair statement. I haven't analyzed that, but that's a fair statement given that the argument here is that we don't need the capacity for more than half of the contract period, thus would be paying for years that we don't have a capacity need. So your counter to that is a different situation, but I think that that would be more acceptable.
Okay. Talk about your issues with the methodology that YELP uses to calculate the avoided cost of capacity. And in particular, I want to start with a discussion of the net versus gross cone methodology. Okay?
Yes.
All right. First of all, just so we're all clear, can you tell me what does cone, C-O-N-E, stand for?
It is the cost of new entry.
And when you use the word net cone, the netting that is occurring, if I understand correctly, is to net revenues that a plant can earn by making market sales of energy against the cost of capacity. Is that correct?
That is correct.
And the gross cone approach, by sort of opposite, is where the cost of capacity is not adjusted to reflect revenues that could be achieved through the sale of energy into the market. Fair?
Fair.
We pause for a moment, and I'm going to circulate a couple of other documents, please, Mr. Chairman. Let's get those two, which will be 12 and 13. That's 13. Where did we get out? This is just to keep you on your toes. Did you get a 13?
I did. Oh, I got a
that's
12.
12.
Nope,
Yep.
there we go.
Okay. Wait, I have 2 copies of the same. Where's yours? Missing. Which one did I make? This is okay. All right. Mr. Pellicory, excuse me, do you have what had been marked for identification as YELP 12 and YELP 13 before you, sir?
I do.
Okay, let's talk about these each. Okay. First, would you agree with me that YELP 12 is a document from Northwestern's electric tariff, and it's labeled Annual Power Cost and Credits Adjustment Mechanism? Do you see that, sir?
Yes, that's the label.
Okay, and Northwestern files these tariffs with the Montana Public Service Commission, is that fair?
Yes.
I would ask for the admission of YELP Exhibit 12 by administrative notice.
No objection.
No objection.
YELP Exhibit 13 is, if you look at the top, that's also from Northwestern's electric tariff. Do you see that, sir?
I do.
And that's the Schedule QF1, the Qualifying Facility Power Purchase Tariff. Do you see that?
Yes, it is.
Okay. And again, this tariff is filed with the Montana Public Service Commission, correct?
It is.
Okay. I'd move for the admission of YELP Exhibit 13 by administrative notice.
No objection.
No objection.
So ordered.
Okay. So I want to try to understand what happens first to the revenues associated with these off-system or market sales for power plants that Northwestern owns and operates. Okay, sir? So if I could call your attention to Exhibit 12.
Okay.
Do you see there that in the first page, number 1, there's a section of this which is called Power Costs and Credits. Do you see that, sir?
Yes.
And listed on the credits are in little Romanet I, something called sales from FERC account 447. Do you see that, sir?
I do see that.
Would you agree with me that the sales that we're talking about here that are recorded in FERC account 447 are market-based sales made by Northwestern?
I don't have the knowledge of that
Okay,
in this case.
fair enough. Let me see if I can ask you this from a generic principle. Are you aware that revenues obtained by Northwestern from the sale of electricity in the market, i.e. to someone other than your retail customers, are used to offset fuel costs otherwise charged to customers through this annual mechanism?
Conceptually, I'm aware of that, yes.
Would you agree with me that in the rates that Northwestern charges to your retail customers, the fixed capital costs of your generation fleet remain unchanged in how those are captured in rates, regardless of the level of revenues generated from the market sales of energy?
I'm not a rate expert. Conceptually, that sounds correct.
Okay.
Yeah.
Let's talk about YELP 13. And specifically tie this to your testimony. At your testimony, can you please refer to, hold 13 with you, sorry, and look at your testimony at page 8, and let me know when you get there.
Okay, I'm here.
At page 8, line 5, you have a question there which says, has Northwestern used the net cone method for calculating avoided costs of capacity and other Montana Public Service Commission, parentheses, commission dockets? Do you see that, sir?
I do.
And you answer that question, yes. And you referred specifically to then Northwestern's QF1 tariff, correct?
I do.
All right. So let's take a look at YELP 13. Is this the QF1 tariff to which you referred in your testimony?
Well, this is the old one, but yes, we have refreshed the QF1 tariff, which is proceeding in the future, but yes.
Right. So to be clear, this is the one that's in effect at the moment. There's a proceeding ongoing that might change this.
Correct.
Okay.
Yep.
Relative to the moment one, this is when you wrote your testimony, this is in Justin, this is the schedule you were referring to, correct?
That is.
Okay.
Yes.
Would you agree with me that, at least as it exists today, the let me back up a second. Can you turn to the second page of this exhibit?
Of YELP 13?
Yes, sir.
Okay.
Okay. So you would agree with me that perhaps that the QF1 tariff as it currently exists has a couple of different options for how the QF is paid, correct?
That is correct.
Okay. Would you agree with me, if you look at page 2 and page 3, all of these options currently contemplate the QF being paid entirely on a dollars per kilowatt hour sold basis?
Yes, in this table, that is correct.
Okay, and for the optional rates on the next page, those are all expressed as rates paid on a dollar per kilowatt hour sold, correct?
That is correct.
Would you agree with me that there is no precedent cited in your testimony where the commission used a net cone methodology to reduce a capacity payment, i.e. a payment on a dollar per kW month basis for a QF, correct?
Thus far, no.
Okay. And you would agree with me that in the commission's decision in the YELP case recently, the commission did not reduce the capacity payment based on your recommended net cone methodology, correct?
It did not. It wasn't in that proceeding either.
Okay. Is it? Perfect. Oh, here it is. Yes, it is. Perfect. All right, we get him permission to approach the witness, Your Honor, or Mr. Chairman. For those in the room, I'm going to have Austin hand the witness a copy of a notebook, which includes the Northwestern 2023 IRP, which has been admitted in this proceeding already, but because it's electronically, I just have a copy for the witness, but that's the document to which I'll be referring. And I think, I don't know if we have the ability to pull it up if anybody wants to, but that's what we'll be talking about. Would it be helpful? Maybe, Mr. Chairman, let's pause for a moment, maybe let's pull that up so that as we go through this, the commissioner and counsel for Northwestern will have that in front of them.
It's the 2023 IRP, sounds like. Got a question here.
Yes, sir. Oh, are you talking?
Let's just be off the record for a few minutes until this is resolved.
That's what I was looking for. Fair. Fair. Okay. And if I could, Mr. While we're on break, we're also going to be referring to the attachment to the response to YELP 23, which is a spreadsheet. We may want to have that pulled up as well. It was included with Northwestern's exhibits that they identified in their pre-hearing memo. It didn't get loaded up. Apologies. Okay. So it will. I'm sorry, I'm getting two questions at the same time. Volume 1, please. It's a 2-volume thing, but we'll only be talking about stuff in volume 1, I believe. And then, I'm sorry, what was your question? It's Northwestern 20. It's Northwestern 23. It was your question to us about the work paper for Mike's testimony, and it's the original unmodified version of the capacity chart. Is that not the right? Oh, sorry.
Mr. Nelson, we're back on the record.
Technical assistance. Mr. Pellicori, you now have the 2023 IRP, which was submitted earlier by administrative notice. Do you see that, sir?
I do.
So I'm going to ask you, because I think you have control over this, if you could scroll down to page 73. You know, I should just leave it on. It's like, thank you. So once again, scroll down to page 73, and it's tiny little way it's presented here. Okay. Can you read that on the screen there, or if not, can you make it bigger? I know what it says, but
Yeah, it doesn't look like I can make it bigger, but I can read it. Let's see. Yeah, I can't control zoom it though.
Okay,
So-
well, we'll give this a shot and see if this will be a little eye test for you. If it's helpful, oh, that's right. It's in
Yeah,
it's
I'm
in that
good.
notebook too.
I can see it.
Okay. Ann, are you cool with this? Could you see it well enough? Or you? Okay. All right. On page 73 of the IRP, sort of underneath that figure 8-12, there's some text there. Do you see that, sir?
Yes.
And would you agree with me that what that says there is, in addition to the long energy position until 2035, figure 6-5 in chapter 6 shows that Northwestern is long on capacity until 2029 for the winter months, and figure 6-7 shows the summer capacity position is long until 2032 based on RAP capacity accreditation and PRM requirements. Do you see that, sir?
I do.
Would you agree with me that what we can glean from that sentence is that based on the best information available to Northwestern at the time it filed its IRP, that the base case scenario showed a capacity deficit in the winter beginning in 2029. Fair?
I'm going to bounce back up to figure 6.5 very quickly because that's contained in that sentence and I just want to see that.
Sure.
Okay. That's what it says.
Okay, so again, to reset, would you agree with me that what that means is that based on the best information available to Northwestern at the time you filed that IRP, there was a capacity deficit in the base case scenario in the winter beginning in 2029, right?
Figures 6.5 and 6.7 are not modeling results. So that is not speaking to model output. That is it comes from the other spreadsheet, which I can't cite off the top of my head, but it's the capacity spreadsheet that has the accreditations and the load obligation, and it comes up with these different deficit amounts by year.
Okay, and based on that analysis, the conclusion in the IRP is that in the base case scenario, there is a capacity deficit in the winter of 2029, correct?
This sentence isn't talking about the base case. It doesn't refer to the base case. It refers to those two figures, which again are not from the modeling.
Okay. So in 2029, what this says is there's a capacity deficit in the winter.
What those figures 6.5 and 6.7, 6.5 says in 2029 deficit in the winter, correct?
Okay. Now, if you look at the figure 8-13 below, Do you see that, sir?
I do.
So do you see there that in the base case scenario, which is the table in the upper left corner, what this is showing is the addition of, in that light little gray box there, an aeroderivative natural gas fired power plant to be added in 2029, correct?
Correct.
Would you agree with me that the purpose of adding in the base case scenario an aero unit in 2029 would be to ensure adequate capacity to meet Northwestern's load requirements?
In the modeling, that is what the ARS, the Automated Resource Selection Model, was attempting to solve for, which was a capacity need in 2029.
And you would agree with me that the fact that it did that, this is the basis for Northwestern's argument that the proxy resource in this case should be an aeroderivative natural gas power plant. Fair?
That's right. The next planned unit is at Aero in 2020
Okay.
from the modeling.
Right. Now, you would agree with me that in other scenarios, for example, in the coal strip retires in 2030, coal strip retires in 2035, et cetera. In those other scenarios, in addition to, well, we'll start one at a time, I guess. In the coal strip retires in 2030, would you agree with me that the unit that gets added in that tiny little black box there on the far left is an ICE unit, right?
Yes.
Okay. So if coal strip retires early, instead of an aeroderivative unit to meet the capacity need, you would be adding a ICE unit, correct? In that scenario.
That's correct.
And then in addition to that, the big blue lines, for example, are additional pumped hydro storage facilities, and then a big gray line there as you move forward in time with additional aero plants, correct?
That's right.
Okay. And if you look at the other tables, what you see there are the capacity additions required in 2029 or later, based on different scenarios analyzed in the IRP. Is that fair?
It is.
Now, one thing I did want to note here, so the years in this are a little bit tricky, but it does appear, if I'm reading this right, that in the fourth scenario where it says coal strip replaced by renewable and storage in 2025, you see that scenario, sir?
Yes, I do.
If that were to come to pass for whatever reason, there would be a capacity addition even before 2029, as noted in this table. Is that right?
That is right.
Okay. If going back to the base case scenario, first, maybe for illustration, do you have an understanding of what is meant by the base case scenario?
Yeah, it's our expected load, the expected resource mix in our portfolio. It's generally, just our base expectation. Or, it's not a perturbed scenario. It's not an early retirement sort of one like the rest of these are. It's our expected case, which should represent reality.
And do you think it's reasonable for the commission to rely on the analytics that are presented as part of your base case scenario in the IRP in thinking about the potential need for future capacity additions?
I think it's reasonable to rely on that to look at what our next planned unit would be.
Okay. Let's talk about the little gray box there for the, first of all, my understanding is that, even though it's hard to read, that's a 50 megawatt unit. Would that be your understanding?
In the base case?
Yes, sir.
Correct.
Okay. So in 2029, okay, what is noted from the discussion above is that there was a capacity deficit in the winter. Do you recall that, sir?
Referring back to the earlier figure.
Yeah.
That is correct.
So if Northwestern built and put into rates a new aeroderivative gas plant in 29 as projected in the IRP, do you think Northwestern would expect to recover 100% of the cost of that plant, or only 25% of the cost of that plant because the capacity is only needed in the winter?
I would expect Northwestern would attempt to collect as much as possible from that plant.
Fair enough. All right. Can I ask you to turn to now the spreadsheet that we pulled up, which was an attachment to the response from YELP's response to Northwestern 23. Let me know when you have that pulled up, sir.
I think it's not sharing each screen as I toggle.
Yeah, and my experience, you may have to turn off the old screen sharing and then load it and turn it back on.
Okay. Yep. Thank you.
Excellent. Okay. Mr. Pellicore, I will represent to you that what Northwestern 23 is a data request asking for Mr. Gorman's work papers. Do you see the title of this spreadsheet, MT, Montana, Capacity Forecast 1/18/23 for IRP? Do you see that, sir?
I do.
So do you understand this to be the table that we talked about a little bit already today, which sets out the different projects and their capacity values done for purposes of the 2023 IRP? Is that your understanding, sir?
Yes, this was used in the 2023 IRP.
Okay. And you're familiar with this table, are you not?
I am.
Okay. All right. So at the bottom of the table, there are some tabs. The first one, which is currently showing on the screen, is the winter WRAP capacity forecast. Is that right?
Yes.
And that shows the capacity forecast there on row 10 during the winter months in each of these years depicted above. Fair?
It does.
And then the next tab over is the same analysis for the summer, right?
That is right.
Okay. So if we look at the winter tab and you look in column L, that's the 2029 tab, right?
It is.
And at row 10, it shows a -18 figure. Do you see that, sir?
I do.
And so would I be correct that that's the capacity shortfall in the winter of 2029 that, as depicted in this chart numerically, that we've been discussing today? Is that fair?
That's fair.
And then if you turn over to the summer one on the next tab, sir, if you can
Yes.
control that. And you'll have to move over to the right just a touch. Okay, so right there on column, now this is my eye test, O, that in row 10 is showing a 32 megawatt capacity shortfall in the summer of 2032. Is that correct?
It does. And these capacities all stem from the assumptions down below it.
Sure.
So under these assumptions with these plants that are being counted, that's what the deficit is.
Yeah.
It's a scenario.
Understood. And okay. So in the context of so this analysis that you've presented here, would you agree with me that this captures the base case scenario that was presented in the IRP?
I can't say it's 100%. I think it's pretty close. But I'd really have to compare side by side right now to answer that.
Okay. So let's go back to the winter version, because that's where my notes are from. So, all right. If you scroll down to the group of resources labeled Wind Generation Advanced.
Okay,
You see that, sir?
I do.
Okay, and so you see there are 4 projects listed: Wheatland, Pondera, I don't know if I'm pronouncing that correctly, Teton and Jawbone. Do you see that, sir?
I do.
Okay. And you would agree with me, and you can scroll to the right if you need to, that in this analysis presented in the IRP, the capacity assignment for Wheatland, Pondera, and Teton were all 0, correct?
That is correct.
Okay. Would you scroll down the list a little further to the hybrid QF advanced? Okay. The hybrid QF advanced category is a group of projects called Caithness, Beaver Creek, 1, 2, 3, and 4. Do you see that, sir?
I do.
And you would agree with me that in this analysis, the RAP capacity forecast presented in the IRP, the capacity assignment for all of those resources through this planning period is 0, correct?
It is in this instance. Yes.
Okay. Okay. I could have just a moment. Discovery response. That was in this book here somewhere. Permission to approach the witness, Mr. Chairman. We're going to go back to the Northwestern's response to YELP 9, which relates to the RAP versus ELCC. Okay.
Mr. Chairman, I don't want to prematurely interrupt, but there is a little crossover between Mr. Steitzer and Mr. Pellicore, and YELP 9 is Mr. Steitzer's name. So I guess we'll proceed and see where we go from there.
In fairness, that sort of is where I'm exactly heading. And maybe let me see if I can cut it off shortly in doing this. Mr. Pellicore, have you ever seen the question and answer labeled YELP 9 that Mr. Steitzer?
I have seen it.
Okay.
I'm clearly not the author.
Okay. I just wanted to check this because I know that there's some overlap in your areas. Do you disagree with anything Mr. Steitzer said in this discovery response?
Give me a second to read it.
Okay.
I don't disagree.
Okay, very good. Okay, I want to talk for a moment about the Western Resource Adequacy Program, or RAP, which is a topic you discussed in your testimony. Do you recall that, sir?
I do.
Would you agree with me that it is possible for utilities who are currently participating in the non-binding phase of the RAP to withdraw their participation prior to the time the binding phase commences?
It sounds possible, yes.
As you sit here today, can you guarantee can you guarantee which utilities will ultimately choose to participate in the binding phase of the REP once that begins, if it begins?
I cannot guarantee. I can only say that there are over 20 participants that, run the gamut from public utilities, investor owned, and so on, that all have signed on to RAP, and it seems to me to be a very robust process. And I have no reason to doubt that it would fall apart.
But I suppose, in fairness, it could, couldn't it?
Anything can happen.
Okay. The last thing I want to talk to you about is the idea that's in your testimony that in any month when there is not a capacity need, as Northwestern has defined it, there should not be a capacity payment. Do you recall generally that position that you took in your testimonies?
I do.
Okay. First, I want to make sure that I understand how it is that that translates into Northwestern's proposed capacity price. Would you agree with me that based on that policy decision or policy recommendation, what Northwestern did was to look at the 240 months of the contract and determine which of those months had a capacity shortfall? Step one. Is that correct?
That's step one. I will say that the specific calculation would be best referred to Mr. Steitzer.
Sure.
That is step one, conceptually.
Agreed. And I'm sort of struggling here because you guys overlap a little. So I just want to make sure that we have that. And so I appreciate that. And anytime I ask you a question that you want to refer to the later person, feel free to do so. That's the glory of going first. Okay. So when you did that sort of conceptually at a high level, am I correct that what happens then is you collect this bucket of dollars for the months in which there is a capacity deficit. You then levelize those dollars over the full 240 months of the contract. And that's how Northwestern derived the $3.23 capacity payment, correct?
Correct.
And now, having said that, your contract, again, maybe some overlap here, you don't actually express the capacity payment on a dollars per kW month basis. You express that as a flat dollar amount of $175,000 and change. Is that right?
Partially. We do use the $175,000 amount. But we also have in the PPA the $3.23 quantity, I think specifically in Exhibit D.
Okay, so let's take a look at that.
Okay. Oh, sorry, it's not in Exhibit D.
That was the question I was going to ask you. So maybe we'll take this one step at a time. So if you look at Exhibit D, in Exhibit D, which is the exhibit labeled capacity payments, is that correct?
Correct.
There it says that the seller will pay $175,469 each month, right?
Correct.
And that calculation, as I understand it, is based on the 323 multiplied times the average capacity over the month, so that it doesn't actually vary summer to winter. Is that right?
That is right.
Okay. Now, having said that, if you look at Exhibit D,
Okay.
notwithstanding the fact that the calculation is done the way it is done, would you agree with me that under Northwestern's proposed language, YELP is obligated to meet its capacity commitment of 51,000 kW in the summer and 57,000 kW in all other months in each and every month of the 20-year PPA, not just those months where Northwestern identifies a capacity shortfall, correct?
That is correct. The way Exhibit D is structured is summer months and all other months. So that is 12 months. I will point out that both PPAs, the one from YELP as well as the one with my red line, had the same structure there.
Well,
12 months.
Sure, but YELP has a full capacity payment every month, which is different. So in your illustration, you have done a calculation. Now, would you accept, subject to check, that I did this math and Northwestern is proposing in the capacity payment section to pay, well, to reflect a capacity payment in 73 of the 240 months of the contract. Would you accept that, subject to check?
Subject to check. It sounds reasonable.
Okay. So if that's correct, understanding the exact number you may quibble with, if that's right, the price you pay is based on getting value from Northwestern's perspective in 73 months. But the obligation you impose is to provide capacity in each and every one of those 240 months, isn't it?
There is a capacity requirement in Exhibit D for every month.
So doesn't that mean that when you calculate the price for that capacity, you are paying YELP $0 for all of those months where you have a capacity requirement, but which you allege there is no capacity need, right?
I would say we don't have a capacity requirement based on Mr. Steitzer's exhibit that will elucidate that a little bit more. But there are a number of years, more than half of the interval, where we don't have a capacity requirement. Consequently, that payment calculated, the $3.23, omitted those years.
Well, I get that, but you don't omit the requirement to provide the capacity, just the payment for it, right?
There is a capacity requirement in Exhibit D.
Okay. Would you agree with me that the PPA precludes YELP from selling energy or capacity to anyone other than Northwestern?
It would. It's an agreement between YELP and Northwestern.
Thank you. I have no further questions of the witness. Thank you.
I'm sorry, Mr. Brown? Can we remove this chart from there? We need that chart anymore?
We do not.
Okay, we can go back to who we have connected to us. Mr. Brown?
No questions.
Thank you. Feeling that. Commissioner Fielder, do you have any questions for this witness?
It's going to take me a while to digest all that, Mr. Chairman. Thank you. So no questions at this point.
Thank you. Commissioner Panocci? Commissioner Bukajay?
No questions, Mr. Chairman.
Thank you. I have one thing that I was confused about. I'm not trying to get to the legal definition of what planned resource is or next planned resource, but I don't have a page listed here, right under figure 1 of your testimony. It says table 1 below, and it says based on the 2023 IRP, it shows the addition of YCGS in 2024 Colstrip, and a Vista and an Arrow. So it seems to me that one of the parties is claiming that the next planned resource to be added is the Arrow. But it seems here to show that it's Yellowstone County Generation Station. And so when you say the next planned resource, does that mean it's planned to be initiated or it's planned to come online?
That it is planned to be, it's a new build, right? So YCGS is not a new build. It wasn't a new build at the time of the Leo date in October. It was under construction. The next new build would be this Arrow unit at Dave Gates.
Okay, I'm just confused, and I can check with people later on as to why the next one to come online is not the most accurate, pertinent figure to use on the next planned one. It just doesn't seem to make sense to me.
Yeah, in the time period between the decision to build YCGS and the Leo date, we issued a new plan and redid our modeling with YCGS already in there. Okay, so this new Arrow at Dave Gates is based upon our freshest modeling, our freshest inputs. That is our next plan. YCGS was already in the modeling to come online. And so the modeling found a new need in 2029. That's the 50 megawatt unit.
Okay, that's
50 megawatt unit at Dave Gates.
Thank you. Ms. Wester, do you have any questions for this witness?
Staff does have a few questions for Mr. Pellicore. My first question, can you just please confirm that Northwestern has only proposed to use the net cone methodology to calculate avoided capacity costs only in the pending QF1 docket and this present docket?
That's correct.
Could you please explain why Northwestern hasn't proposed the net cone methodology previous to those two dockets?
I can. So energy markets have evolved, and Northwestern Energy joined the EIM in 2021. And with that, we now have LMP pricing for every generator node in our BA. We now have the ability to price energy at those real-time prices for each generator node. So that facilitates our ability to separate energy and capacity. And so consequently, we've adopted this new, proposing this new net cone methodology because we have that new information adapted with the markets, so to speak.
For the record, can you clarify what BA stands for?
Balancing authority. Yeah.
And my last question for you, are you aware of any other utilities, regional transmission organizations, or independent system operators that have used the net cone methodology to calculate avoided capacity costs?
My understanding is PJM on the East Coast uses net cone. CPUC uses something similar, is my understanding as well. And I believe there's a few other RTOs/ISOs that use. I haven't done a full market analysis on that, but that's my understanding.
Okay, thank you. That's all the questions I have.
So recross, Mr. Nelson. It shows here, recross and then redirect.
Yes.
Just going by the script. In any case, Ms. Hill.
Thank you, Mr. Chairman. Just to clarify that your last answer, I think you said CPUC. What does that stand for?
That's the California Public Utilities Commission.
Okay, thank you. And staff asked you about the dockets where Northwestern has proposed this net cone approach. I believe it was confirmed QF1 docket and this docket. Can you think of any more? The 302 docket.
302
There.
docket.
Now we're even. Just one other follow-up. Do you recall Mr. Nelson asking if sitting here today, You can guarantee route participation.
I do.
Did Yelp ask for avoided cost calculated as of today?
No, they did not.
Thank you. I have no further questions.
Uh, My script is.
Nothing further either.
If I could clarify for a moment, the commission does typically allow the party that does cross-examination to recross after commission questions. If you did have a question, you would have had the opportunity to do that before redirect.
And I understood the opportunity to ask cross based on commissioner questions, which I had no questions for. So
Thank you.
I'm
And
completely happy with the sequence.
I apologize if I prematurely jumped in. I got out of order.
Excused. I think it's, we'll temporarily excuse this witness. Thank you.
Thank you.
Is there any reason why we can't permanently excuse him, or do you just want to, just in case?
Well, I don't know. Not being a party to the case and with all the detail, I don't know.
Well, Northwestern asks that this witness be permanently excused.
No objection.
No objection.
Okay, well, then we'll permanently excuse this witness. Thank you. You have to guarantee that we're not going to have any questions for you. Yeah, I know, because you won't be here. So, Ms. Hill.
Thank you.
Ms. Hill, we've been an hour and 20 minutes of an hour and 30 minutes prescribed time. This seems like a convenient time to take about a 10-minute break.
Thank you.
Off the record.
While we're off the
Okay, it is now 2:29. We're back on the record. So you were calling another witness, I believe.
Thank you, Mr. Chairman. Northwestern calls Mr. Matthew Steitzer. Good afternoon. Could you state your name and business address for the record and spell your name?
Matthew Steitzer, MATTHEWSTAJCAR. My business address is 11 East Park in Butte, Montana.
And who is your employer?
I'm employed by Northwestern Energy.
What is your title at Northwestern?
I'm an energy supply planning analyst.
Did you submit pre-filed testimony in this docket?
I did.
And do you have that testimony before you?
I do.
And is that the intervener testimony of Matthew M. Steitzer?
It is.
Do you have any corrections to your testimony?
No, I do not.
If I were to ask you the same questions in your testimony here today under oath, would your answers be the same?
They would.
Mr. Chairman, I move that Mr. Steitzer's testimony be admitted as Exhibit NWE 2.
Objections?
No objection. Sorry.
No objection.
No objection.
So admitted.
I tendered this witness for cross-examination.
Good afternoon, Mr. Steitzer.
Steitzer. Good afternoon.
I'm delighted to meet someone whose name is even harder to pronounce than mine. My name is Thor Nelson. I'm an attorney for YELP in this proceeding, and I do have just a couple of questions for you this afternoon. To start with, could I ask you to turn to your testimony at page 10?
I'm there.
On page 10, would you agree with me that you discuss how you derive Northwestern's proposed capacity payment of $175,496 per month? And you specifically say that that's calculated as the avoided cost of capacity rate of $3.23 per kW QCC month, multiplied by YELP's annual average accredited capacity of 54,333 kW QCC, correct?
That's correct.
Would you agree with me that the PPA requires YELP to provide 51 megawatts of capacity during the 4 summer months and 57 megawatts of capacity in the remaining 8 months, correct?
That's my understanding.
Would you accept, perhaps subject to check, if you don't know, that if you take 51 in 4 months and 57 in 8 months, that derives an average value of 55 megawatts?
Subject to check. That sounds accurate.
Now, would you agree with me that even though the PPA requires YELP to provide 55 megawatts of average capacity, your calculation only calculates a compensation based on 54.333 megawatts of accredited capacity, correct?
That's correct.
So if under the contract, if YELP actually only provided you the 54.333 average megawatts of capacity, so they did what was expected, you would actually, through the contract, reduce the capacity payment by the difference between that 55 and 54.333 average megawatts, right?
So that would be a provision in the PPA that I did not represent. So I'm not sure.
Okay. When Northwestern seeks to recover the cost of its generation units from ratepayers, does Northwestern propose to collect 100% of the costs of its generation fleet, or a discounted percentage of those costs based on the difference between nameplate and accredited capacity?
My understanding is Northwestern would seek to recover 100% of the fixed costs.
Can you please take a look at, is it still up there? The contract's up there? Did you hand him 9? Okay. I've asked to have placed before the witness a copy of YELP Exhibit 9, which is the YELP PPA. Do you see that, sir?
I do.
All right. If you look on the very, very last page of that document, on Exhibit D, let me know when you see that.
All right, I'm there.
Okay. Just want to put this data point out there for comparison, but you would agree with me if you look, for example, at section 1.3 of Exhibit D at the very bottom of that paragraph, the capacity payment in the YELP contract was $25.14 per kW month, correct?
This just says 2514, but I agree.
Okay, fair enough. Now, by comparison, Northwestern's proposed capacity payment, as we just discussed for YELP, is $3.23 per capacity month, derived and calculated in the way we just spoke about, right?
Correct.
And would you accept that YELP's proposed capacity payment is $27.56 per kW a month?
That's correct.
Okay. Can I please ask you to pull up one of your exhibits, which is in a spreadsheet, which I think is perhaps available there. And in particular, I'm going to ask you to pull up MMS1. You could let me know when you have that and we are able to share it to the screen so everybody else can see it as well. Yep. All right. What we're showing up here on the screen is your exhibit MMS1, which is a electronic spreadsheet. Is that correct?
That's correct.
If I could ask you please to navigate to tab 10. Are you there?
I am.
Oh, sorry. I can see it. You're there. I don't have to wait for you to tell me. Excellent. All right. So and actually we have a spreadsheet. Maybe we could actually do the math here. I wanted you to take a look at row 23 as it's labeled in the line number, not as it's labeled in the spreadsheet, if you understand what I mean by that. Do you see row 23 there, sir?
Is this the correct row?
Yes, that's it exactly. All right. In that row, would you agree with me that what you are showing is the total levelized rate of the proxy resource, which is calculated as you proposed as a 50 megawatt aeroderivative unit. And you show that annual rate to be $247.40, correct?
That's correct.
Okay. Now, if I wanted to convert that to a monthly capacity rate, would I be correct that you would divide that by 12?
A month, yes,
Okay.
for a 12-month year.
Would you accept, subject to check, or if you feel excited, you can make the spreadsheet do it for you, that if you divide $247.40 by 12, that translates into a capacity cost using your methodology of $20.62 per kW month, right?
I agree.
Okay. Now, what's being shown here, though, as we go from line 23 down to lines 31 and 32, that's the impact of the calculation that you've done to estimate the difference between what we've been calling here so far today, the gross cone and the net cone. Is that correct?
Lines 31 and 32 represent the net cone, yes.
Right. So in comparison to the line 23, when you apply the net cone effects, again, you have to do just a little bit of math because this is expressed as dollars per megawatt month. So you have to divide that by 1,000 if I understand the way this works correctly. So on a dollars per kilowatt month basis, after you apply the net cone methodology, that has the effect of reducing the capacity payment before that we just talked about down to $17.74 in the summer and $17.76 per kW month in the winter. Would you agree with that?
I would agree, and just note that the capacity rates on line 31 and 32 are divided by the 9 wrap months,
Okay.
not 12 calendar months.
Okay, but on a per month basis, thankfully, we just have to divide that by 1,000 because it's megawatts to kilowatts.
Sure. Yes.
Very good. All right. Now, that is the number which you then use in the table that we'll get to in a moment to assign a capacity payment value in the months of the contract when you have determined, or Northwestern has determined more broadly, that there is a capacity shortfall, correct?
Correct.
Okay. So essentially, the difference between that 1774 or 1760 down to that $3.23 level, that delta is because of Northwestern's conclusion that capacity is only needed some of the time in the contract, right?
That's correct.
Okay. Okay. Now, would you agree with me, going the other direction, that the difference between that line 23 figure we discussed, the $247.40 per year or $20.62 per month, the difference between that number and YELP's proposed capacity rate, that ties to the differences in how the two of us are disagreeing over the cost of the proxy unit. Is that fair?
I'd agree.
Okay. Okay. One thing I wanted to show is, could you go to tab 12, please? All right. So just so we're clear, this is the tab which shows each of the contract months, excuse me, and actually some months before the contract. So if you look, for example, on what's row 68 of the spreadsheet, if you scroll down, that's where the contract term begins in 2029 or 67. Is that correct?
That's correct.
Okay, and then there's a bunch of dashes there. Those dashes represent the fact that in that month, your calculation of the capacity rate is assuming 0 in terms of a payment to YELP, because there is no capacity shortfall, right?
That's correct.
And then you scroll down through the years, lots and lots and lots of zeros, until you eventually get to June of 2040, right?
That's correct.
Okay. Now in June of 2040, the calculation changes in part. Here it changes because Northwestern believes there is a 10.4 megawatt accredited capacity shortfall in June, July, August, and September of that year, correct?
That's correct.
And so for that, then you assign a partial capacity payment to YELP in the amount of 10.4 accredited megawatts times the $3.23, right?
No, not multiplied by $3.23. The 10.4 megawatts of accredited capacity would be multiplied by the 17,000 and change.
Right. Sorry, the 3 happens later. Thank you for that correction. Okay. And then moving on in June of 2041, and if you scroll down beneath that, now we see sort of pretty regular numbers where month over month, there are frequently capacity deficits, which are then calculated out in terms of providing value, right?
That's correct.
Okay. But if you look starting here and go all the way to the bottom, would you agree with me that in every year, in April and May and October, there's no dollars assigned to the calculation for capacity provided in those months, right?
That's correct.
Would you agree with me that under the PPA, if you know, Northwestern requires KELP to provide capacity under the contract in each of those 3 months for the entire life of the contract?
That's my understanding of the contract.
Okay. We have just a moment, Mr. Chairman. Okay. I want to talk for a moment about the methodology you used to calculate the net cone deduction to the capacity credit that you did. I'm going to ask you a general question, and then we'll see whether or not it's necessary to refer to your documents, because I will confess to you, this is a very, very big exhibit. And so navigating through it is tricky, but you may not need it for these questions. So would you agree with me, as I understand what you've done, the source of the math in support of the change from the gross cone to the net cone is based on information from 2021 about how much off-system market sales Northwestern made using the Dave Gates power plant. Is that right?
No, I would not agree with that. The net cone calculation is derived from the gross revenue subtracted from the variable costs of an aeroderivative unit of the like units at Dave Gates. So they're not necessarily market sales.
Okay, so and here's what this is what I'm trying to figure out. So when you say gross revenue, first, am I right that we're talking about information from 2021?
2021 through July of 23.
Okay, so when you say gross revenue, what is the source of those revenues?
The gross revenue refers to the megawatt output of the Dave Gates generating station units multiplied by the 5-minute LMP market price.
So that revenue includes all of the power that Dave Gates is producing that serves Northwestern's retail customers, in addition to whatever power is being produced that serves non-Northwestern customers?
It's power that's being produced to produce energy or provide ancillary services.
Okay, so in your understanding, the revenues that you are calculating, which you say should offset the cost of capacity, includes revenues generated from the retail rates paid by Montana retail customers based on energy produced by Dave Gates.
Can you repeat your question?
Sure. The gross revenue calculation that you've made for the energy produced by Dave Gates includes revenues paid by Northwestern's retail customers for the power that was produced at Dave Gates and used to serve Northwestern's retail customers.
I'm sorry, I'm getting lost in your question. Can you try one more time?
Sure. Maybe I'll take a step back. I was under the assumption, possibly incorrect, that the revenues that you were looking at were only revenues when the power plant sold power off system into the market. What I'm now thinking is what I'm hearing is that the revenues that you are assuming includes that, but also includes the revenues Northwestern gets from your regular Montana customers in their monthly bill for the portion of that monthly bill that is associated with power that is supplied by Dave Gates.
I'm going to object because there's an assumption in their question that there's a bill for selling power from DGGS. If you can break it down, I think there's an incorrect assumption in there.
Well,
it seems to me that the witness did say just it's the quantity times the 5-minute whatever rate right there, which is included all of the power that's sold, whether it's sold to the market or sold for native consumption. So I think what it seems to me what Mr. Nelson is trying to do is to break those apart, but show that his figure is all of those together, but only do by breaking them apart and then bringing them back again.
Yeah.
I'll let the witness clarify.
Okay.
Thing is, I think the witness brought it up when he talked about the.
So I'll say the gross revenue is calculated from the energy produced from the units at Dave Gates multiplied by the 5-minute LMP. It is not specific to energy serving Northwestern's retail customers or off-system sales. It's all energy produced multiplied by the LMP.
Okay. And okay, now what I also think maybe I now understand is that when you say gross revenue, you're not measuring the actual revenues that Northwestern got. You're making an assumption that here's all the power Dave Gates produced, and if Northwestern sold that at the LNP price, here's the amount of money that would generate.
That's correct.
Okay. And so in this context, what you're saying relative to the proxy unit is you look at all of the energy output of that proxy unit. You assign a market price to that. And then your position is that that revenue should be discounted from the capacity price paid to the proxy unit, right?
That's correct. The reason the energy or ancillary services are removed is because the capital cost of that specific unit, an aeroderivative unit, may have different operating capabilities than a different capacity resource. And so it's appropriate to remove those to calculate the pure capacity of the proxy.
So you understand that a proxy unit in this context, an aeroderivative unit, it burns gas and incurs costs when it burns gas, right?
That's correct.
And there are costs associated with the capacity to construct the facility in the first place, right?
That's correct.
Okay. So I guess what I'm trying to figure out here is when the unit burns gas and incurs those costs, under the contract, there's a market rate that gets paid for that energy. Do you understand that?
The market price of electricity?
Right.
That's correct.
So if that market price of electricity is then also used to reduce the capacity payment, how does the proxy unit get paid for the gas it consumes?
So the net cone methodology is to remove the energy and ancillary services from the proxy resource. The cost of gas is associated in that calculation of removing that cost to generate. So
how do they get paid for fuel? I mean, I get it works in a renewable world where there's no fuel, but in a world where there's a fuel cost, if you don't get the market payment to pay for the fuel, there's nothing there, isn't there?
Well, again, this is for the proxy resource to pull out the energy portion from the levelized cost. It's assumed then that this avoided cost of capacity that's applied to a QF in this example will dispatch at their marginal rate in which their LMP price is greater than their variable costs. So they're not dispatching at a cost that's less than what their fuel cost is.
Okay, so I guess what I'm trying to say here is that, would you agree with me that for the proxy unit, there is a capacity cost that is existing regardless of how much energy is produced or sold? Fair?
I would agree.
And there's an energy cost, which is most importantly the cost of the fuel that's burned to produce the energy. Do you agree with that?
I agree.
I guess what I'm saying here is, if the money you get for selling energy is the market price of that energy, and you turn around and reduce the capacity payment by that same market price, you have no dollars left to pay the cost of the fuel for that proxy unit, do you?
But I think you're mixing the difference between the proxy unit and the unit that's getting paid as the QF. So the proxy unit is to calculate the avoided cost of capacity. That gets paid to the QF. The QF then has the opportunity to generate at times when it's economical. They receive that energy payment.
But, okay. in the context of YELP, if the idea is the capacity payment is reduced by the energy market value of all of the energy produced, and the only thing you get paid for your energy is the market value of the energy produced, by eliminating that on the capacity side, doesn't that mean that there is essentially no payment for the energy?
No, I wouldn't agree with that.
Why?
So when we do a net cone calculation, that cost of capacity is paid to the QF based on the months of need. That, aside from the mechanical availability and the terms of the PPA, aside from that, the QF gets the capacity payment regardless of what energy they produce. The QF then gets, in addition, the energy, the QF in addition gets energy revenues from the amount of energy they produce at a market price.
Right, but the capacity price is reduced by the amount of energy your proxy resource is assumed to create over the course of the year, isn't it?
Yes, I agree.
So in that instance, well, I guess maybe what you're saying is if YELP produces more energy than the proxy resource, we get a rate for that. But up to the level of the energy the proxy resource is assumed to create, because that level is a deduction to the capacity payment, there's no energy payment for that essentially, right?
So I think there's confusion of the proxy resource and the QF resource do not have to produce the same amount of energy. The net cone calculation separates energy revenues from the proxy resource so that it's only valuing pure capacity. It's up to the QF to generate when it's economical to produce energy revenues.
Okay. I think that horse is as dead as we can get, but I appreciate that clarification because frankly, that wasn't the way we understand what you were doing. So I have a better understanding now. All right. Let's talk about the choice of the proxy resource. You recommend that the proxy resource be a 50 megawatt aero unit that you have located for illustrative purposes at the Dave Gates power plant. Is that fair?
I believe that was Mr. Pellicori's testimony, but that is Northwestern's position.
Well, that's the price you calculated is based on a 50 megawatt unit at Dave Gates.
I agree.
Okay. If there is a future capacity need for Northwestern, would you agree with me that that capacity need will be met through a competitive RFP process?
It could be. It could also come from an opportunity resource.
Would you agree with me that the bidders in that RFP could bid conceivably any number of different technologies, including, for example, a RICE unit? Fair?
Sure.
Would you agree with me that at the time that Northwestern decided to build Yellowstone, that Northwestern considered the possibility of instead building units at Dave Gates?
I believe a unit at Dave Gates was bid into the RFP, yes.
And at the time when Northwestern decided which was more economical, would you agree with me that Northwestern picked the Yellowstone units over units at Dave Gates?
That's what happened, yes. I will say I'm not certain of the technology that was bid in at Dave Gates.
Okay. Can you look at your testimony at page 4?
I'm there.
Okay. You have a question there at that point. How did Aon, and I guess, am I pronouncing that correctly, first of all?
I believe it's Ion.
Ion, for the record, that's AION. How did Ion develop cost estimates for the Aero? Do you see that, sir?
I do.
All right. And you answered there, Ion developed candidate resource cost estimates, including the Aero, for Northwestern's 2023 Montana IRP. ION's cost estimates were derived from peer utility IRPs such as Avista, Black Hills, Idaho Power, Montana Dakota Utilities, Pacificor, Puget Sound Energy, and Excel, as well as industry publications from the National Renewable Energy Laboratory, the U.S. Energy Information Administration, the Northwestern Power and Conservation Council, and Lazard's Levelized Cost of Energy Analysis. Do you see that, sir?
I do.
Okay. So would I be correct in assuming that based on your testimony there, that your calculation of the cost of the aeroderivative unit is not specifically based on any actual natural gas power plant constructed in Montana, right?
That's correct.
ION is a consulting group, is that right?
That's correct.
And ION is not here before the commission to explain how they derived their cost estimates for that power plant, are they?
No, but I'm aware of the information that was used in that cost estimate.
Would you agree with me that the analysis as presented in your IRP does not identify any specific actual natural gas generation facility whose costs were used to develop that estimate, right?
I agree.
Would you agree with me that the cost estimate does not include the cost associated with providing firm gas transportation to the power plant?
In ION's report, it does not. In the avoided resource, the proxy resource that was included in the calculation, it did include 20 hours of diesel backup fuel.
Sure, but it doesn't include an actual pipeline
Sure.
upon which you have firm transmission rights, right?
Agreed.
Okay. Is it possible for winter storms in Montana to last longer than 20 hours?
Yes, unfortunately.
Okay. Can I have a moment, Mike? My computer just decided to shut down. I don't know what's going on with that, so I need to pull my colleague's computer here for a second. Do you have... What did I use? No, well, that's not very helpful then. Okay, that's all right.
You need enough time for us to be off the record.
I don't. If it would be convenient for the commission, that'd be fine. I think it will take me about 2 minutes to pull up the right document.
Let's go off the record for about 5 minutes. Thank you. It's now 3:07.
Nope. Nope. I need one. Nope.
Okay, we are back on the record. It's 3:08.
Okay. Mr. Pellicore, one last line of questions I just want to highlight here. Can you please go to your exhibit MMS1? Oh, I'm sorry, that's not your exhibit. No, and you're not Mr. Pellicore. Oh, God. I was like, wait, this is your exhibit, but I named you wrong. I'm so sorry. Mr. Steitzer, can you please go to your exhibit, which is MMS1, right?
I'm here.
Okay, excellent. So sorry about that. Can I please ask you to go to, and I'm losing my microphone probably. Can I ask you to go to tab 2, which is, you have to scroll over to the left to find, and let me know when you have that in front of you.
I'm here.
Okay. So, I wanted to ask a couple of questions about this calculation, because this, would I be correct that this part of your analysis, in particular focused on the stuff at the top, shows how you take the estimated cost of the proxy resource and adjust that over time, given that we're doing a calculation for a contract that runs from 2029 through 2049. Is that correct, sir?
So the 2029 reflects the avoided resource, the 50 megawatt proxy resource. Yes.
Okay. So just to highlight how this works, the proxy resource you used, if I understand this correctly, is what's identified there on line 4 as the dual fuel gas CT. Is that correct?
That's correct.
So in 2025, for example, that shows an installed cost of $1,969 per kW, correct?
That's correct.
Okay. And then as you follow the chart to the right, what happens is that dollar declines, right?
That's correct.
So for example, the cost declines in 2029 to $1,889, right?
That's correct.
And then it declines down. If you look all the way out to 2040, it declines down to $1,776. Is that right?
I agree.
Now, am I correct, first of all, that when you did your calculation, because there was no capacity need until 2040, your calculation uses the 1776? Or am I incorrect, and did your calculation use the 1889?
My calculation used the 1889 value.
Okay, very good. So that value then was de-escalated. Now, in terms of how you de-escalated it, would you agree with me that you have there beneath the table what you call table 4, which is an excerpt from the IRP, right?
Table 4 is from the IRP.
Okay. And am I correct that what this table is telling us is in the IRP, there were assumptions made about the impact of technological advancement on the costs of these resources considered in the IRP, right?
That's correct.
And so, for example, there was a generic assumption for 2023 and 2024 that technological advances would reduce generation costs essentially across the board by 2.44% in each of those years, correct?
No, I don't believe that's correct. I believe in the report, if you read it, I believe they said the technology advancement was flat in those years.
Okay. Having said that, and I suppose either way, it probably doesn't matter, because if I understand what you did correctly, you commenced the, if I'll call it the de-escalation process, starting in 2025. Is that right?
So I'd say starting in 2026, when the numbers change, there were 2 escalation factors applied. One was a rate of inflation, and one was a technology advancement rate from the NREL ATB report from 2022. NREL is the National Renewable Energy Laboratory. ATB is the annual technology baseline trend. And the cause of the overall de-escalation of the overnight capital cost of these units is due to the fact that the inflation, the positive escalation, is smaller in magnitude than the technology advancement escalator that is larger in magnitude in a negative direction.
Okay, so let's unpack that just a little bit. So the data source you used, as shown here, is called NREL 2022 ATB trends, right?
That was an input into ION's report that was used in the 2023 IRP.
Okay, NREL is the National Renewable Energy Labs.
That's correct.
Okay. You consider NREL an expert on natural gas power plants?
Yes.
Okay. You don't actually put in here the trends for all of the resources. It's just essentially baked into the number that's shown above, where you decrease the cost from $1,969 in 2025 to $1,889 in 2029, right?
You're correct. They are baked into this tab. However, we did provide those complete files to YELP.
Okay. So essentially, though, what this is saying is your belief, based on this NREL data, that the price for new natural gas power plants will decrease at a rate greater than the rate of inflation between 2025 and 2029, right?
That's correct.
Based on that, is Northwestern willing to commit today that if you build a gas plant in 2029, it'll be cheaper than YCGS?
I can't say that.
Didn't think so. No further questions.
Thank you. Mr. Brown? We remove this from the screen.
Thank you, Mr. Chairman. No questions. I'm going to be unavailable for about the next 20 minutes, but then I'll be back.
Thank you.
Thank you.
Commissioner Fielder, any questions?
No, thank you, Mr. Chairman.
Thank you. Commissioner Pinocci? Okay. Commissioner Bukic?
No questions, Mr. Chairman.
Thank you. I can't refer to page numbers of your testimony. It's not on my copy right here. So the question, what page is it? Why did you evaluate Northwestern's capacity position using the RAP QCC values? Are you familiar with where that is in your testimony? It's like on page 4 or 5 or something like that. It's rather near the front, I think.
I'm not familiar with the page number, but I can speak to that.
So your answer was, as explained in Mr. Pellicori's testimony, the RAP QCC values were used to evaluate Northwestern's capacity position because this was how Northwestern plans its resource portfolio and the 2023 IRP as stated in multiple locations. So, you know, just again, not being trained as an attorney, it sounds to me like Northwestern is saying that they want to use a standard of the RAP program for capacity, even though it's not binding, it's not in effect, and may not actually come about. But they're also willing in your testimony later on to say that they want to keep the resource stack of companies that are not projects that are not going to be completed. So it seems like they're saying in the resource stack, you have to do this as of the LEO, but we're going to put a different standard on the capacity using the RAP program. It seems to me, if you're going to be consistent, everything should be done by the LEO date. Seems to me, for what's in effect at that time. Does that make sense to you?
Sure, I'll try to address your comment in 2 parts. So Northwestern is using the RAP QCCs not only for YELP's QF dockets, for future QF dockets, but for our standard portfolio planning as of today. So that is not different between QFs. To your comment of including resources as of the LEO, it's my understanding that this commission has said that that is the time when avoided cost of capacity should be calculated at the time of their LEO. And at the time of their LEO, these resources were in Northwestern's resource stack. That answers your question.
Well, that's an answer to the question. That's not necessarily makes it clear to me, but thank you for offering that. And I say I have a very competent staff who will explain things to me further. It's my confusion. So, staff attorney, any questions? Okay.
I have a couple questions regarding portfolio planning. I wanted to reference your response to data request PSC-003A, in which you stated that for Northwestern's 20-year capacity forecast used for long-term planning, Northwestern does not consider capacity requirements for the months of April, May, and October. So my first question is it true that Northwestern still requires capacity to meet load in April, May, and October?
It does.
And can you explain how Northwestern plans to meet load in those months, April, May, and October?
Sure. I mean,
Generally,
we're meeting the load with the resources in our portfolio. The reason we don't plan for capacity in those shoulder months is because the RAP does not require us to do so, and so there's no financial penalty to maintain capacity in those months. April, May, and October are shoulder months where typically there's a lot of they're non-peak months, and so it's a prime opportunity for generators to take maintenance, and so there's often outages in those months, and so it's not a high load month, and so that's why that's taken during that time, and so there's no penalty during that time to hold capacity because of the consideration for plant maintenance. One of the reasons.
okay, thank you. Actually, might have one more question coming up here from staff. Final question for you. Is it true that Northwestern can opt in to have the shoulder months be binding in the REP program?
That's not my understanding, but I don't know that for certain.
Thank you.
Thank you, Mr. Chairman. No questions.
Thank you, Mr. Chairman. I'm going to attempt to add clarity. Mr. Steitzer, at the time of the LEO in October of 2023, did Northwestern have any reason to believe that RAP would not be binding in 2029 when YELP's PPA started?
No.
Thank you. That's all I have. Northwestern asked to permanently excuse this witness.
No objection.
Mr. Brown? Oh, that's right. He's gone. You are permanently excused. Thank you very much.
Thank you.
So, Ms. Hill, next witness.
Northwestern calls Mr. Patrick Powers. And I want to note for the record that the pressure is on Mr. Nelson to finish this hearing today.
I don't have a flight till Friday.
I'll take you to dinner.
By the way, point of personal, Dan, did you have the remote for that air conditioner in the back? Could we fire that up? I think I'm getting very uncomfortable.
It's on.
It is. Okay. Maybe the back door needs to be closed then. Showing, was it 74?
Ready?
Please.
Mr. Powers, could you state your name and business address for the record?
Yes, Patrick Powers, and business name is Northwestern Energy. You want an address too? I'm sorry. 11 East Park is the address.
And you're employed by Northwestern Energy, as you just stated, correct?
Correct.
And what is your title with What is your title?
My title is the Director of Grid Real-Time and SCADA Operations.
Did you submit pre-filed testimony in this docket?
I did.
Do you have that testimony before you?
Yes, it appears so.
And is that testimony identified as the intervener testimony of Patrick M. Powers?
Yes.
Do you have any corrections to your testimony?
No, not at this time.
If I were to ask you the same questions in your testimony under oath here today, would your answers be the same?
Yes.
Mr. Chairman, I move to admit Mr. Powers' testimony as Exhibit NWE 3.
No objection.
Thank you. So it had been,
And I tender this witness for cross-examination.
Thank you. Good afternoon, Mr. Powers.
Good afternoon.
We talk a lot, so I don't feel the need to introduce myself to you.
Yeah, good to see you.
Good to see you too. All right. I have a couple of broad questions that I'd like to start with, just to maybe level set on how the interconnection issues work. So first of all, you would agree that Northwestern and YELP currently have a power purchase agreement that provides the terms and conditions under which YELP sells electricity to Northwestern, correct?
Yes, that is correct.
And that agreement is set to expire at the end of 2028, correct?
Yeah, my understanding is December of 2028.
And that agreement includes within it the interconnection terms and conditions that the two companies operate under. Is that right?
Yes, there are some terms of interconnection within that PPA. Yes.
Okay. As we sit here today, YELP does not have a standard large generator interconnection agreement, or LGIA, with Northwestern, correct?
That is correct.
But would you agree with me that to the extent your testimony discusses requirements under LGIAs, today those don't apply to YELP, right?
Today, they do not apply. Correct.
Do you understand that YELP is not subject to the requirements of NERC?
I'm not fully aware of all their compliance under NERC. We still show that there is registry as a generator operator for YELP and BGI within NERC, but I'm not completely positive of their compliance obligations.
Okay, can you, I forget what the chairman called it, not a notebook, the tome. Can you grab the tome for me, please? Permission to approach the witness, Mr. Chairman? Can you pull up JB 7, please? From Mr. Bieber, rebuttal testimony? Yep.
Okay.
Mr. Powers, did you have occasion to review Mr. Bieber's rebuttal testimony in this proceeding?
I did, yes.
I've put in front of you Exhibit JB 7. Do you see that, sir?
Yes.
Well, that's a letter from NERC to YELP dated September 28th, 2008, correct?
Correct.
If you look at that first paragraph of the letter, it says, NERC intends to remove Yellowstone Energy Limited Partnership, NERC Compliance Registry ID number NCR 0, maybe NCRO, I guess I'm not sure, 5479 as a registered entity in the NERC Compliance Registry as of September 18th, 2028, correct?
I do see that.
And then later down, it says in the fourth paragraph, being deleted from listing in NERC Compliance Registry indicates that an entity is no longer subject to the mandatory compliance with NERC reliability standards that have approved by the commission. Do you see that, sir?
I do, with one note. It shows the function as a GO, not a GOP.
And the commission being referred to there is the Federal Energy Regulatory Commission, right?
Are you referencing a certain section? I'm sorry.
The sentence on the fourth paragraph says it's no longer subject to NERC reliability standards that have been approved by the commission. NERC reliability standards are approved by FERC, not the state commission, right?
Correct.
Okay. All right. You don't have any evidence that you've presented in your testimony to contradict that letter that NERC sent, do you?
No, I did not present nothing.
Okay. Now, I want to talk through what I think is kind of the seminal question as it relates to the interconnection arrangement, which is a question of when. Would you agree with me that setting aside the question of a potential future interconnection request, as to the actual terms and conditions in the LGIA that YELP presented to Northwestern at the 57 megawatts that were studied by Northwestern, that except for the effective date issue, all the rest of the terms and conditions the parties agree with. Is that fair?
I think there was general agreement around the interconnection proposal or request. There was some concern relative to how YELP was going to be able to meet the terms of the agreement. We did not receive anything back to show how they would meet power factor requirements, for example, under section 9.6 or functional governor response as well under 9.6, because we hadn't seen it in the past.
Do you have any reason to dispute the testimony offered by YELP that there may be additional facilities that YELP needs to procure in order to fully meet the obligations of the LGIA?
No, I do not dispute that. We just did not know it at the time going through the process.
Do you think it is unreasonable to ask that compliance with the terms of the LGIA should be deferred until such time as YELP has the ability to comply with the agreement?
I think that's something that the parties would negotiate and have communication with and establish timelines and know it has to be there.
Okay, so I want to ask a big picture question here, because this is, I think, what you don't want. And that is to say, you don't want the commission to order you to sign the form of the LGIA that YELP has presented. What I'm not sure is what you do want. So could you please lay out for me what you believe the path needs to be to get from today to a point where by January 1st, 2029, the parties have an executed large generator interconnection agreement?
Yeah, so Northwestern had concerns with signing an agreement that we weren't sure how could be met. So I think coming together and that understanding, as we just talked about, and that may include additional equipment, which has been brought up in this testimony. The other thing that we need to understand is the actual interconnection amount. So the interconnection request was for 57 megawatts. We had heard that the facility had planned to generate as it had in the past, which we know at times is over 62. So therein lied concern as well. So I think fleshing out the details is really what needed to be done.
So, okay, so can you give me, do you know, what are the step-by-step process to do generically what you're saying? How do we get from here to there?
Yeah, so right now there was an interconnection request with the 57 that's been brought up. If the facility really planned to generate above that, I think they would come up with a request for the value they plan to generate to. And then we would look closer at the requirements, such as power factor and functional governor, and how do we get those to the facility to meet those requirements.
Okay, so, and I apologize, but I really am trying to be very, very specific. So Is it your recommendation that Yelp withdraw the current interconnection request or supplement with an additional interconnection request for the increment from 57 to 65?
Objection. Northwestern has opposed Yelp's proposal. It's Yelp's burden to prove its case, and it's not Northwestern's burden to solve the problem for Yelp. So our testimony did not propose alternatives to Yelp's proposal.
And Mr. Chairman, if I might, this objection goes to the very core of the problem. Northwestern has never, to date, provided a clear path forward for how we can get to interconnection, which means from Yelp's perspective, the only option we have is to get the commission to order interconnection at the level we've asked for, and then sort these details out later. And the point of this examination is to demonstrate that Northwestern is and has never been willing to commit to a path forward, creating the real risk that on January 1, 2029, Yelp will be unable to accomplish interconnection and be unable to comply with the PPA.
I have to dispute that characterization. Yelp filed the petition without talking to us.
Okay. That's it. Yeah. There was a lot of discussion, but that's neither here nor there.
I'll overrule the objection, basically because it seems to me that that Yelp provided a suggestion for the LGIA date, and if I have this incorrect, and Northwestern said no. So it would seem to me to be the burden would be on Northwestern to say no, but this. It would seem to me, is that reasonable, Mr. Nelson?
That is precisely what I'm trying to understand, because what I don't want to have happen, and what Yelp is frankly afraid of, is if nothing is ordered in this case, there is then no clear path forward. And I'm about to go into a discussion with the witness about why the future of the interconnection process at Northwestern, the interconnection queue at Northwestern, is filled with an ocean of uncertainty right now. And that's the problem that I was about to explore with the witness, which I think is absolutely germane to the hearing today, and Yelp's request that the commission at least establish a baseline level of interconnection subject to then potentially future enlargements.
Yeah, go ahead and explain. You're fine. That's fine.
Staff recommends that the commission overrule the objection. We do believe the line of questioning is relevant. Please proceed.
Okay. I don't remember what the question
I was
is.
going to, could you repeat,
don't
please?
either, Mr. Powers.
Please.
Okay. So the first step, maybe let's take this one little bite-sized piece at a time. The first step in an interconnection process, would you agree with me, is an interconnection request?
Correct.
Now, Yelp has made an interconnection request from back in 2023, correct?
Correct.
That interconnection request, or the second step of the process, was then studied by Northwestern, right?
Yes.
And Northwestern determined that based on the interconnection requested, which for good or for ill, was 57 megawatts, that Northwestern had no network upgrades or other facilities that would be required to accommodate that interconnection request, correct?
Can you repeat that? I'm sorry.
Sure. Based on the study that was done by Northwestern for the amount of interconnection requested, Northwestern concluded that no network upgrades or interconnection facilities would be required to accommodate the interconnection request, correct?
That's correct on Northwestern system. Yes.
Okay. Now, if YELP wanted to make a request to increase, well, let me back up before I do that. Would you agree with me that the PPA as proposed by both parties could be followed and complied with using an interconnection at a maximum level of 57 megawatts?
Are you referring to the future PPA or the existing PPA?
Good clarification.
Okay.
The future PPA does not obligate YELP at any time to deliver more instantaneous power to Northwestern than 57 megawatts, correct?
That's my understanding.
Okay. Would you agree with me that an interconnection party has the right to request a smaller amount of interconnection than the power plant is capable of producing?
A party that has an existing interconnection could come in with an incremental request. Yes.
That's not what I said.
Okay.
Let me try this again. If somebody wants interconnection,
okay,
they do not have to ask for a level of interconnection that is 100% of the power plant's output capability. They could ask for a smaller amount of interconnection than the power plant is capable of producing, right?
Yes.
Okay. So in that context, there's nothing wrong with YELP having an interconnection at only 57 megawatts. Fair?
In that context, that's correct.
Okay. So if YELP wants to do an interconnection request for 65 megawatts, say, as I see it, and I want to see if you agree with me, YELP can do one of two things. We could withdraw the 57 megawatt request and file a whole new one, or we could file or request an incremental interconnection for the amount we want to increase. Would you agree with that?
Yes, those are two options. Yes.
Okay. If, and here's part of the problem, if YELP withdraws the 57 megawatts, would you agree with me that they lose their position in the interconnection queue?
Yes. If they re-entered, they have a new position in the queue.
Okay. Would you agree with me that if you don't execute on an LGIA, that you are also subject to losing your interconnection queue position at some point?
At some point, yes.
Okay. Now, relative to the future, would you agree with me that Northwestern is currently, like utilities across the country, undertaking FERC-mandated reforms in how the queue position is evaluated and how projects within the queue are studied? Fair?
FERC has issued orders relative to that. Yes.
Okay. Is my understanding correct that as a result of the FERC requirement redoing the queue process, that Northwestern has announced that it is accepting no new interconnection applications, or at least not processing interconnection applications until 2026, when there will be a cluster study done for the entirety of the interconnection requests that were or have been submitted. Is that right?
Yes, that's my understanding, February of 2026.
Okay. So if YELP withdraws from its interconnection request and does a new one, or if YELP adds that extra 8 megawatts, in either case, that could get put into limbo until the 2026 cluster study
to be done in the future, right?
Are you referring to withdrawal or incremental request? Either way, right?
Either way,
Okay.
my understanding is it gets punted until 2026. Is that your understanding?
It would go into the 2026 process, yes.
Okay. So for the next year and a half, nothing will happen. 2026 cluster study occurs. How long is that cluster study supposed to take?
I'm not positive on the duration.
Okay. Would you agree with me that it could take a while?
Possibly.
Okay. So now we're into 2026, 2027. Is it fair to say that as you sit here today, Northwestern is unable to 100% commit to the commission or to YELP that any study that gets roped into the 2026 Q process would be completed by a specific date?
I can't answer that question for sure. I don't know exact timeframes or can't give any guarantees.
Right. Okay. Now, I know you don't like the idea of signing an agreement today, but not actually having that apply to the interconnection until 2029. I get you don't like that. Here's my question. If the commission did that, if the commission did what YELP said and said, we're going to order this agreement at 57 megawatts, the other 8 megawatts will have to fend for themselves with the 2026 pool. Okay, so they do that. Nothing changes in the current interconnection. January 2029, new interconnection kicks in. Do you have that hypothetical in mind?
Okay.
What is the harm to Northwestern's customers?
The harm if we were to sign an agreement today that's not effective until January of 2029?
Yep.
I think the harm is just not knowing the actual achievables, as we mentioned, for sure, to meet the requirements of the GIA, as well as, they're subject to things changing between now and then that's 4 years down the road. So some unknowns.
Okay, so let's break that down. So you said, so the harm is not knowing how YELP will comply.
Correct.
Okay, but compliance is on YELP, isn't it? It's YELP's obligation to comply, not Northwestern's.
It would be YELP's obligation to comply,
Okay.
But subject to agreement. That's two parties enter an understanding, right?
Sure, but is there any reason to think that if you were ordered to sign the agreement that between now and 2029, Northwestern and YELP can have these conversations that you are mentioning and understand how compliance will be achieved post 2029?
I believe if we were ordered to, we would have to go through that process, right?
Okay. So alternatively, what you're saying is you don't sign the agreement. Maybe we drop out of the queue. We have those discussions and then have a new queue and a new study and analysis sometime in the undetermined future. That's the way you would suggest.
I think that's one of the options you presented.
Okay. Now, the other sort of harm that you sort of indicated is things could change. Now, when you say things can change, do you mean the terms of the LGIA could change?
Potentially.
Okay. So let me sort of unpack the way this process normally works for facilities that don't exist. Would you agree with me that if a facility doesn't exist, they are eligible to sign an interconnection agreement, locking in the interconnection terms and conditions years in advance of the commercial operation date of the power plant, right?
What has happened with new interconnections is that they sign an agreement, and upon acceptance of FERC, it becomes effective. And it starts processes such as insurance and other things. Relative to their commercial operation date, that's subject to when the facility is built and completes their processes.
Sure, but for years, well, you agree with me that the time between execution and commercial operation can be multiple years, right?
Potentially.
So if that happens, if the LGIA changes in between time, that doesn't matter. That developer has locked into the LGIA that they will be subject to at the time they sign the agreement, right?
The time that the agreement was effective, yes, going forward.
Okay. So, but when the agreement is effective in that instance, no electricity is going through that interconnection, right? Because it doesn't exist, correct?
In your hypothetical example, yes.
Sure. So when you say the agreement is effective, I'm putting in air quotes here, there are some communications between the parties that happen, some discussions that happen, but there is no actual exchange of electricity until all the facilities are constructed and the commercial operation milestones are all achieved, right?
There are some things that happen, such as test power and other before commercial operation, but I guess it depends on the timeline you're looking at.
Okay. And that doesn't offend your sensibilities that you have an agreement, you work out the construction, you sort out the process, but no electricity is exchanged until years later when everything is done. That's okay in your mind. Fair?
It's a process that we've gone through before.
Okay. So what I'm trying to understand is, how is YELP any different? Where today we have a system that, as you've already identified, is not ready to move forward. There needs to be construction and process that occurs. So why can't an agreement be signed today, but not operate to have electricity flowing under it until January 1, 2029?
Well, YELP is different because it is interconnected today and generating today versus the example you provided was a new construction type interconnection.
So YELP has less rights than a non-existing interconnection entity would have?
No, not less rights, a different circumstance.
So for YELP, the other generators, they can get a delay while they do their construction. For YELP, we can't.
I think it's a different circumstance based upon what you described.
Okay. Do you understand that when YELP and Northwestern sign a new interconnection agreement, if that becomes effective upon signing as you suggest, that will abrogate the interconnection agreement between the parties currently in the PPA, right?
My understanding is there could have some impact, yes.
Because you can't have two different contracts effective at the same time, right?
I guess if they conflict, there might be a problem, but subject to separate agreements or terms that it really depends on what's in there.
Okay. In your mind, do the provisions of the LGIA, are they in conflict with and different from the provisions of the current interconnection arrangements in the PPA, or are they identical?
There's different criteria within the LGA than the existing structure in the PPA.
Okay. So as I understand your proposal, the LGIA must be effective upon signing. If YELP were unwilling to amend its current agreement that it has with Northwestern, would you agree with me that in order to accommodate the idea that it is effective upon signing, it would have to be signed at midnight on December 31st, 2028?
No, I don't agree with that.
Okay. When would YELP be able to sign an LGIA? Well, back up. So if YELP signed an LGIA the week before, and it was effective on that date, for that last week, the contract would change, right? You would be under the new LGIA, not the old one.
If it was effective upon signing and FERC approval, that would be the case.
Okay. So what I'm saying is, if the idea was we don't want to rip up the current interconnection, we want to let that run its course, but we also want to be able to deliver power under the new PPA on January 1, 2029. How is it that the only way to do both of those things is anything other than signing a new agreement on December 31st at midnight under your scenario that it must be effective upon signing?
Well, I think you just gave an example where it was a week earlier, but it could be some term earlier.
Well, so but but if it's a week earlier, in that last week, Yelp has lost the ability to have interconnection under the old agreement and must abide by the terms of the new agreement, right?
Depending effective dates and how everything came out, there might be a problem.
So your proposal is that this commission approve a process where the current contract is broken and replaced with something new in the moment that it is signed, right?
No, we weren't trying to enforce anything. We were just stating concerns we had with the interconnection.
Yeah.
And how it was submitted.
And this is what I'm saying. If the agreement is effective when it's signed, and the moment it signs, it breaks the contract, and you want to have a new agreement effective January 1st at 12:01, how do you do that other than executing the agreement at midnight on December 31st? Every other scenario you've given us requires the current contract to be broken, doesn't it?
I don't know that given all those scenarios, I think we've talked through some potential cases that could happen. And just like any agreement, I think the parties would come together and try and figure out what needs to be done.
So let me ask you this. Is Northwestern willing to have the commission order today? Northwestern, we order you to execute the interconnection agreement that is currently standard, but we order you to execute that at midnight on December 31st, 2028. So the agreement is effective upon signing, but the commission orders you to sign it on that moment. Would Northwestern be okay with that?
If the commission ordered it and it was something we were obligated to do, I guess that was something we'd have to work through.
Do you understand that? Oh, sorry, I need a document now. Yep. Permission to approach the witness with a document?
Question, how much longer do you feel?
Not much.
Okay.
I think there is a chance, by God, we will in fact finish today. Which I get 40% chance to, in fairness.
Well, I'd like to call a recess.
But
for
we could
5
be
minutes.
perfectly fine time to take a break here, Mr.
5
Chairman.
minutes. So at 4:02, we'll be back on the record.
Solar is looking for Denver.
I'm sorry, what did we decide this thing was? 14. Oh, good point.
That's all that's left, because I know there's a hard cut at 5.
Yeah.
We just have to like read in the record that type of information.
Yes.
That's right. I'm just suggesting, you know, for everyone's sake, because
Well, and his lawyer has left. I think his lawyer is looking for the minutes. Ann, are you guys ready? Patrick has left in protest. Mr. Chairman, Mr. Chairman, it appears the witness is still on break, so. Yeah. Sorry, I was trying to be more polite.
Okay, we'll be back on the record now. It's 4:03. Mr. Nelson was proceeding. Just handed out an document,
Yes.
voluminous.
You good to go, Mr. Powers?
I am.
Okay. Mr. Powers, I placed in front of you what has been marked for identification as YELP Exhibit 14. Do you see that, sir?
I do.
Do you recognize this as attachment M to the Montana OATT or Open Access Transmission Tariff? That attachment being the standard large generator interconnection procedures.
Yes.
I will offer this up. I don't know if the commission has a preference. I would just propose to move this for standard admission. It's possible the commission could take administrative notice of this, but it's a filing at FERC, not at the commission. So I will simply move it in the standard way into evidence.
No objection, and we do note it is publicly available on Northwestern's Oasis site, so again, no objection.
Okay.
Mr.
No
Brown?
objection.
No, thank you. Admitted. Thank you.
All right. Mr. Powers, just to set the stage just a bit, the large generator interconnection procedures, which are sometimes called the LGIP, this documents the procedures through which Northwestern accommodates interconnection and interconnection requests as set forth here, right?
Yes.
Okay. Can I please ask you to take a look at section 11.3 of the agreement? And I apologize, in the way this prints out, the attachment is not paginated. So it's, a ways into the document.
Okay, I believe I'm there at section 11.3 execution and filing.
Okay, great. So would you agree with me, first of all, that this is the portion of the LGIP that addresses the execution and filing of large generator interconnection agreements, or LGIAs?
Yes.
Okay. Would you agree with me that as you look at section 11.3, the LGIP indicates that upon execution, a counterparty to an LGIA needs to establish site control, pay a deposit if there's any deposit necessary for construction that Northwestern is to undertake, and meet one of the milestones set forth towards construction, correct?
Are you referring to a specific section of that 11.3? Just to verify.
Okay, so 11.3.
Okay.
We can read this. Maybe that'll be helpful.
Yeah, I think that would help. Thank you.
You see, it starts within 15 days after receipt of the final LGIA, right?
Yes.
It then specifies what has to happen. 1, the customer has to provide reasonable evidence of continued site control, correct?
Yes.
2, and this bleeds over into the next page. They have to post a $250,000 non-refundable additional security to be applied towards future construction costs, correct?
Yes.
Okay. Any concern that YELP doesn't have site control at the power plant, by the way?
I'm aware that they currently have a facility generating. I don't know long-term conditions of that.
Fair enough.
Okay.
And at least as to the 57 megawatt interconnection request now before you, there's no construction that has been required as being identified associated with that level of interconnection request, correct?
I'm sorry, were you referring to the interconnection request that they made?
Yes.
Oh, I didn't have that in front of me.
Okay, so do you recall that pursuant to the interconnection study that was done, no construction is required to accommodate the 57 megawatt interconnection request, correct?
That's my recollection.
Okay, so because there's no construction, would you agree with me that under the LGIP, there would be no need to post non-refundable security towards future construction costs, right?
Per this, if they met terms of reasonable evidence of continued site control, I would agree with you, yes.
Okay. And then it says, at the same time, interconnection customers shall also provide reasonable evidence that one or more of the following milestones in the development of the large generating facility at interconnection customers' election has been achieved. Do you see that, sir?
I do.
And then it lists 5 different potential milestones. Do you see that?
Yes.
Okay. Would you agree with me that nowhere in 11.3 does it require that upon execution and filing, the LGIA be operated to actually exchange electricity? Does it?
Can you repeat your question? I'm sorry.
Sure. Nowhere in this execution and filing process is there a requirement that upon execution, okay, that the parties actually start transmitting electricity through the interconnection facilities.
No, I do not see that. I just see the need for a contract of sale.
Okay.
Of electric energy.
Sure. And the contract for sale in this particular instance, that's the PPA that we're debating about before the commission. Fair?
Fair.
Okay. You familiar with the LGIP generally?
Generally.
As you sit here, are you aware of anything in this document that requires an interconnection counterparty to begin exchanging electricity through interconnection facilities immediately upon execution of an LGIA?
I'm not aware.
Thank you, Mr. Powers. I have no further questions of this witness.
Thank you. Mr. Brown.
No questions.
Okay. Commissioner Fielder, any questions?
No, I don't have any questions at this point. Thank you.
Thank you. Commissioner Pinocci.
No questions.
Thank you. Glad we got that fixed. Commissioner Bukacek.
No questions, Mr. Chairman.
Thank you. So I did have a question. So Northwestern seems to want YELP to sign an LGIA at any time soon. Okay. Is there any problem that Northwestern is having that having an LGIA come into effect now would solve?
If an LGA was effective near term or today, it would actually benefit the reliability of the interconnection. As I specified in my testimony, there are some requirements under power factor obligation, functional governor response. Those things are very critical to support interconnection and reliability, that is, and it actually would benefit the interconnection as well as customers.
So if it was signed today and had to go into effect today, your answer on your last page of your testimony, you said YELP could agree to comply with Appendix C of the LGA, could meet the requirements specified and follow a voltage schedule, so on. But you indicated that Northwestern was leery of the fact that they felt that YELP might not be able to comply immediately. So you say they could, but YELP has testified, if I understand correctly, that no, they can't, or they might not be able to.
Yeah, and I think you're keen on the word could, as well as we weren't aware of any restrictions that they had. That communication did not happen.
A previous witness, when I asked the question about if it was signed today and therefore YELP was found to be not in compliance with that, what Northwestern would do. And that witness seemed to indicate that Northwestern might use that as a means to cancel the agreement with YELP altogether. That witness even said, as they've done twice in the past.
Are you referring to non-compliance to agreement terms?
The LGIA.
So I don't know if that would be true. I typically what I think would happen is we would try to focus on communication with the parties and see how we could come together and have them meet the terms of the agreement. If they could not, if they failed to meet the agreement, then I think there's circumstance and outcome subject to that.
Lost my train of thought. Let me try and recapture it right now. It's not coming back. It was profound. It was truly profound. It just sort of all the way straight out of my mind at this point. So I have no further questions. Commission staff?
No questions.
So are we through with this witness then?
No recross based on commissioner questions.
Oh,
Thank
okay.
you.
Yes, sorry.
And then I just have a
Late in the
couple
day.
of clarifying
Please.
points. Mr. Powers, could you turn to exhibit JB7, which is the NERC letter Mr. Nelson asked you about?
I way faster than I know everybody's ready to get out of here.
It's a test.
Except I like to see Bobby work. She's so on top of everything in an instantaneous. It's just wonderful. My compliments.
Yes, thank you. Could you turn to paragraph 4 of that letter? I believe, well, do you recall Mr. Nelson asking you about YELP being deleted from the NERC compliance registry?
I do recall that.
Could you finish your statement? I think you said something about GOP.
Yeah, so this letter, in reference to paragraph 4 and being deleted from NERC registry and compliance obligation, if you look underneath that paragraph, it has the region, which is WEC. That's where we operate within the interconnection. It also has the functions of just GEO. So there's another function and registry within NERC, which is GOP. That's a generator operator. There are both WEC and NERC standard requirements that apply specifically to functional registry of a GOP or generator operator.
Do the voltage requirements that you talked about in your testimony apply to GOP?
Yes, that's correct. We'd referenced NERC standard VAR 2, and it is applicable to a GOP.
Okay, and under that language, GO, could you read that next sentence in the letter?
Next sentence, continued voluntary compliance by Yellowstone Energy Limited Partnership with NERC reliability standards is considered practice by the industry and is recommended by NERC.
Okay, I have no further questions. So that's the conclusion of Northwestern's case.
Very good. You are permanently excused. Thank you.
Thank you.
So, Mr. Brown, any case in chief on your behalf?
No, Mr. Chairman.
All right, thank you. So, Mr. Nelson, do you have any rebuttal case?
Thank you, Mr. Chairman. YELP has no rebuttal case or witnesses and would rest its case at this time.
Thank you. So do parties wish to present a brief closing statement or closing arguments? So that would be applicant.
Subject to Northwestern's preference, the petitioner is happy to waive closing arguments in favor of brief.
Northwestern supports that.
Mr. Brown?
MCC supports that as well.
Very good. So we just move into scheduling conference. Oh, yes. We'll next ask for final public comment. If you wish to comment, please wait. And is there any public comment in the room? Any public comment online? No? Okay, very good. So then, thank you. So seeing none, we'll now move off the record to the record scheduling conference. So we are off the record.
And I will defer to what the parties agree to for what it's worth.
Just.
Oh, what? Sorry. Oh. Thank you. We are back on the record. The evidentiary portion of the hearing is now closed. And we are back on the record. The time is 4:27. The results of the conference will now be read into the record by Commissioner Attorney Webster as an order of the commission, and no separate scheduling order will be issued.
Thank you, Commissioner O'Donnell. Parties have agreed that post-hearing briefs will simultaneously be due for all parties on November 6th, 2024, and response briefs will be due on November 26th, 2024. Thank you.
Very good. So for the record, the time is 4:27 p.m. The date is September 25, 2024. This hearing is adjourned.
Thank you, sir.
Good.
Nice job, Mr. Chairman and staff and all the parties there today. It was very good information, and I appreciate the efforts.